Good morning, ladies and gentlemen. Thank you very much for joining us on the second day of our conference and in our first panel, which is focusing on challenges to competition law in the digital era. Our first presenter will be Mr. Tihamér Tóth. He's a Jean Monnet Professor of Pázmány Péter Catholic University, Chairman of the Scientific Council of the Competition Law Research Center, and the coordinating co-author of 3 manuals on the subject of Hungarian and EU competition law. Currently, he's a judge at the General Court of the European Union. I suppose we can start with the presentation, if all the technical background issues are working, and we can greet Tihamér in our
Good morning, can you hear me?
Panel.
Az nem az volt, ez a Tóth Andrisé.
Good morning.
The presentation will focus on the application of the EU state and aid rules with a view to promote digitalization without undue competition distortions.
Good morning.
Good morning, Tihamér. We are here. Can you hear us?
I am so. Can you hear me?
We cannot hear you.
Okay.
That's great. Now we can hear you. So please take the floor, and we are looking forward to your presentation.
Thank you very much, Judith, for this kind introduction. Can you please just confirm once more that you can hear me and see me?
Everything is working perfectly.
Excellent. The slides are on the wall. Everyone is eager, prepared, hungry for knowledge. If so, then thank you again thank you to my colleagues, to my friends to organize this wonderful conference, co-hosted with our Indonesian friends. I'm really sorry that I cannot be among you in person, but thanks to this wonderful technology, I'm still able to present my thoughts on a topic which is quite unique. It is meant to kind of broaden the horizon of this 2-day conference, to speak about European competition policy related topic which goes beyond traditional antitrust platforms, abuse of dominance, and topics like this. If I can get some help with turning the pages of my, thank you very much. So, as stated, control is a quite unique European phenomenon. I think it's maybe useful to give you a very quick overview how this European policy functions. In a nutshell, we have a clear prohibition of anti-competitive state aids enshrined in Article 107 of the Treaty on the Functioning of the European Union. This seemingly strict prohibition is watered down by various exceptions, exemptions, so that in the end we can find many lawful state aid projects going on at European level. But we have a control, a screening mechanism, which is by its nature very much similar to what we have in merger control, talking about antitrust. And the thing is that member states, whenever they want to introduce a new state aid project, a state aid plan, as a rule, they have to notify the European Commission and wait till they get the positive decision. We have, luckily, a so-called general block exemption regulation, also a de minimis rule for small aid, which means that all those aid measures which are covered by these two legal instruments are exempt from this notification, from this lengthy waiting period, and they can be implemented immediately as long as they meet the conditions of this block exemption and the de minimis rule. Very importantly, we have a significant sanction which hits on mainly companies, the beneficiaries, and not the member states themselves. And this is that whenever a company receives unlawful state aid, it has to be repaid, recovered with interest, and that may hurt, and that may even lead to the bankruptcy of some companies. Competition policy covers at European level state aids. It's a very unique segment of competition law, though, because the decisions are not only influenced by these mainstream competition law ideas around efficiency, consumer welfare, freedom of competition, and things like this, but it's a field of law which is basically belongs to economic law, where other public interests like social policy, environmental policy, foreign policy may also play an important role. If I can move to my next slide. So how to reconcile these two big topics, digitalization, digital markets, and state aid? It's no surprise to you that we in Europe are front runners in regulation, not only as regards the abuse control of big American companies, but also in general, in the digital world. If you look around, there are many, many angles, dimensions of digitalization, which have already been regulated or are just about to be regulated at European level. Just think about, for example, the liability of platforms vis-a-vis consumers, or the recent regulation of the labor law status of gig economy workers. We have this wonderful Digital Market Act, which has been addressed yesterday by many speakers. Now, of course, we have cybersecurity, GDPR, and artificial intelligence regulation is also on the agenda now. So regulation is clearly a very important role played by European institutions. Second, we have funding. So let me just recall two bigger funding instruments with a digital relevance. For the current budgetary term running till 2027, we still have this Digital Europe program funding various projects relating to supercomputing, artificial intelligence, cybersecurity, and things like that, with a budget of 7.6 billion euro. In addition to this, we have an even larger budget, which is mainly due to the COVID crisis. It is meant to handle the negative economic impacts caused by the economic restrictions related to the COVID crisis. This is the well-known Recovery and Resilience Facility. The budget of this is 672 billion. So much, much larger than the Digital Europe program. It covers grants and loans. It is not exclusively about promoting digitalization. The main focus is maybe on greening the economy. Yet, when member states apply to get funding from this European budget, they always have to submit programs which include at least 20% projects related to digitalization. We also have such a program in Hungary, which is, you are well aware, is unfortunately suspended right now. But once it can be implemented, for example, Hungary would spend great amounts of money on digitalizing education, healthcare, and various aspects of our public transport network. And finally, there we have state aid control, the topic of my presentation today. Some of you might not be experts in the state aid law field, yet we always have to bear in mind that it is a very important segment of European competition policy. Just looking at the numbers, it's been obvious for years that the European Commission deals with much more state aid law cases than antitrust, not only in the digital field, but overall. Also, if I look at my current institution, the General Court of Justice, the General Court of the European Union, at the end of 2022, this is the latest figure I was able to get, looking at the pending cases, the cases we are here at the tables of our judges, we had almost 300 state aid law cases and only 62 antitrust cases. Antitrust including mergers and abuse of dominance and cartels. So really it's a huge area with important practical consequences for member states and for undertakings. If I may get my next slide, here I give a few examples for what kind of areas of the economy are targeted by state funding at member state level, which is then subject to European competition law control. Well, you can imagine that in this field, we don't speak very often about these American giants, the big platform owners, the big social networking companies. They are almost never the beneficiaries of state aid granted by member states. Yet we will talk about infrastructure building, broadband networks, manufacturing of electric batteries. It's a key component of our digital economy. In Hungary, you know, we are kind of front runner in this industry as far as investments and state aid subsidy are concerned. And you can see there supercomputing, semiconductor industry. So there are many fields which can be and are subsidized by European member states. Well, the extent to which member states spend public money on these industries is, of course, varies depending upon the national economic priorities, about our belief in the capability of markets, of private endeavor, and the role of the state. But yeah, this is the case. So whenever member states spend public money on these industries and in these infrastructures, the European state aid control will kick in. And my next slide, I give you, it's important to have a quick view of what the concept of state aid is, because it's a very, very broad concept. It goes way beyond what most people would consider state aid. This is subsidy, so giving cash to companies. That is also state aid, but in addition to subsidies, we have many other forms and types of state aid, which is controlled by the European Commission. So here are the elements. What I'm talking now is Article 107 of the treaty. First, the Commission always have to show that there is an advantage, there is a benefit received by undertakings. In most cases, it's quite obvious. However, for example, when we have a public investment action or a public loan at advantageous conditions, or granting of land by a municipality to new investors, it can be a tricky exercise to prove that this transaction included an advantage. We have this market economy investor principle elaborated to be applied in these cases, which means simply that whenever the company or the member state can show that the same transaction would have been carried out by a profit maximizing private entrepreneur under the same conditions, there would be no state aid. So there's no aid then. Second, the beneficiary has to be an undertaking, which is the same concept we have under antitrust. So any entity which carries out an economic activity. This means, for example, that aid given to individuals purely for social purposes or aid given to local municipalities are excluded from the concept of state aid control. Third, the aid must be selective in nature, targeting not everyone, not every undertaking in the same country, but having a kind of focus. This means that general measures like a general countrywide decrease of income tax, of turnover tax would fall outside the scope of state aid control. What we need is that either we have a aid which targets only one single undertaking, or it targets a selected industry like digitalization or broadband networks or telecommunication or airports. Or the third option is that is when the member states give aid to any company, to any undertaking, which is in a certain region, in an underdeveloped region. These are the regional aids. They're also selective by their geographic reach. Fourth, the aid must be given obviously by the state or from state resources. There must be state attribution. The state must be responsible, must be behind the aid measure. And finally, of course, we have to prove that this aid thing distorts competition and affects trade in the common market. It's very important to know that the aid can take any form. As I told you, going beyond subsidies, the creativity of states is, of course, limitless. They come up with different versions, different types of aid. Yet we have to know that also the concept of state aid is limitless. It's very broad. It basically catches every kind of state intervention, which fulfills the above-mentioned conditions. On my next slide, let's apply this concept to our topic, so digitalization. Here I give you a few examples how the concept of state aid played a role in cases related to digitalization. First of all, we know that the beneficiary must be an undertaking, so an entity carrying out an economic activity. This means, for example, that when the targets of the aid are public administration, like governments, offices, introducing various digitalization technologies, normal public hospitals, traditional universities, then we don't have state aid control. It doesn't fall under Article 107. Why? Because the recipient is not a so-called undertaking. We have to be careful though, because there's a kind of gray area here. It's a misty field of law. We don't have, we lack some clarity whenever the recipient is a educational entity, or it's in the healthcare or health insurance fields. There, the European case law is not entirely clear from which point we talk about a public entity and from which point the concept of undertaking begins. Second, for example, relating to Pázmány Péter Catholic University, which has an important faculty dealing with various biotechnology researches. We also have a research laboratory, a research institution set up by the university. Whenever public funding is targeting traditional educational functions or traditional basic research, so not industry related, but basic research, European law would conclude that this is not an undertaking. The university is not an undertaking in this respect. Therefore, there is no state aid control here either. My third example is more directly related to digitalization. We have many examples for countries, like recent cases from Italy or Cyprus, where the government spends money in the form of vouchers, giving either to every family, every household, or maybe subject to some social restrictions to less wealthy households, a kind of voucher, targeted money so that they can buy digital tools like laptops, iPads, or they can subscribe to broadband internet services. This usually is in force for 1 year or maximum for 2 years, these kinds of state measures. In this case, at first sight, one could maybe think that, okay, but here the recipients are households, natural persons, families. And I told you that we need to have undertakings as a beneficiary. Yes, that's true. However, our concept of state aid is very broad. It also covers indirect forms of state aid. And this is exactly the case here, because it is true that directly it's households who benefit from the aid in the form of vouchers. However, they must spend it. They can only spend it on the services of certain companies, of a certain given industry. The beneficiary of all these measures are, in most cases, telecommunication companies offering broadband services and related products. So it is regarded as a form of state aid. I'm not saying that it's a bad state aid, that it's illegal always. On the other hand, to the contrary, it's widely accepted, it's exempted, it's authorized by the European Commission as a form of good state aid. Second example, selectivity. It's also an important component of our state aid concept. In most cases, it is quite clear. There are not many legal disputes about that. However, for example, we had an interesting case from Spain, which lasted, well, you can see on the slide, many years. The initial complaint from a competitor who did not receive aid, handed down in 2009, which resulted in a commission decision prohibiting the state aid. The aid related to at that time it was an important topic, the move from traditional television broadcasting to digital broadcasting TV. And this process was subsidized by the Spanish local government. However, the Commission found that this state aid did not respect an important condition. This is technological neutrality. And for that reason, it was prohibited. Later on, however, even though the General Court agreed with the Commission's conclusion, or appeal court, the European Court of Justice, thought it otherwise and annulled the Commission decision, saying that the Commission did not properly prove that the aid was selective, that the recipients of the aid were in the same or in comparable competitive position than those who did not receive the aid. So, for example, this seemingly simple case resulted in a long legal procedure, and finally the Commission adopted a new decision 2 years ago, again prohibiting the discriminatory state aid, now with a much more elaborate, detailed explanation of why the aid is selective, according to the Commission. State resources, a very fascinating topic. If you recall my second slide, where I showed you that we have a few European funds, European money, promoting digitalization. There you may ask the obvious question that is there really state aid involved in these cases where undertakings, companies receive funding from the European budget? It is aid, it is selective, it may distort competition, yet it's not coming from member states. And it's important to realize that European law in this field regulates only the activity of member states. Article 107 is not meant to supervise what European institutions do, right? So here we have a long established principle which is of course difficult to apply in practice, but the principle is clear, which is that whenever member state authorities have discretion to allocate these European monies, when it flows through when the European money flows through national budgets, in those cases, it will be regarded as if it was a source of the national budget, which implies that the state aid control will take effect. It's an interesting question, a bit open question, whether, for example, the Digital Europe program, projects financed by the Digital Europe program are covered by state aid control or not. Interestingly, the regulation which is about this program is silent about this issue and does not refer expressly to the ex ante state aid control, which should be put into place. Now, looking at my watch, I'm a bit behind my schedule, so I may jump my next slide, which is about a general introduction of how state aid can be authorized. And I would just shortly mention that we have this very important general block exemption regulation, which by now, it's a very long regulation, many official journal pages, and practically it covers most types of member state subsidies of aid given for so-called good purposes, for research, development, technological innovations, environment protection, saving workplaces, and things like that. By good aid, I refer also implicitly to the fact that we also have bad state aid, and that usually covers operating aid, when the aid is simply given to companies to survive, to fill their pockets without any additional conditions on investments, developments, and things like that. This is bad aid, never allowed as a rule, and also export aid. So aid which is conditional upon moving products, services within the European Union. This is also unacceptable. But all the other kinds of state aid, if you have a good argument behind that, if you can prove that it serves not only national, but also European interests, can be authorized. And very often it is covered by this block exemption regulation, with the important consequence that the projects doesn't have to be pre-authorized by the Commission. And as you can see on this slide, the Commission did its best to modernize this regulation. Recently, it was updated from a digital perspective, even though before the amendment, the regulation covered many digital innovation related projects. Now it's even more clear that most state aid supporting digitalization will be covered by this block exemption regulation, which is good news for companies, good news for member states. Finally, two quick slides about real life examples. I told you that broadband, the rolling out of broadband networks is a very important policy objective for the European Commission. We have these magic figures, numbers of reaching 5G ultra-fast networks with 1 gigabyte downloads. This area has been subject to a guideline regulation since 2014, if I'm not mistaken. Right now, we have a new guideline which took effect this year. Again, reforming the existing policy line, which is, to put it simply, is that member states have to carry out a mapping exercise, identifying those regions, those cities, those parts of the cities in the country which have underdeveloped networks, where, for example, there is no broadband network provider or there is just one. And for these areas, they can get state aid quite easily. It's interesting to know that you can also get state aid in very competitive areas, like in big capitals, which are called on this slide as black areas. black usually reflecting that you have a small chance to getting state aid approval for this kind of regions. But it is still an option, but there you have to invest a lot. There you have to triple the speed of the available internet capacity. So it's a very interesting policy document. For those of you who are interested in, you can find it online. It's about 40 pages long, so it's a very detailed policy document giving you an idea how, to what extent European Commission, European law intervenes into national economic policies. And finally, maybe a bit funnier and easier example to conclude my presentation. Most often, state aid in the digital sector is approved on the legal basis that it helps to promote a European interest, a project of European interest, or it facilitates the development of a certain economic field. However, in a few rare examples, you can also see that culture can be a legal basis for exemption, like in this Irish recent example, where the Commission approved individually. It was not covered by the general block exemption regulation, so it had to be approved individually. An Irish plan to subsidize, to give aid to those companies with a seat in Ireland who agree to promote culture through video games. It's an interesting form of state aid. You can see it's a tax credit, which is limited by up to 8 million per beneficiary, per undertaking. There are also, of course, the restrictions, conditions on how much aid you can get in relation to the whole cost of the project. In this case, it's 32%, so it's not that much. Yet it was regarded by the Commission as a type of necessary aid, which was also proportionate to this wonderful and legal aim to protect European culture. And here I would suddenly stop, because my time has been over. I thank you very much for your attention. I hope you were able to follow my thoughts online, and I will stay, of course, with you in this panel discussion in case you have questions, comments, or answers, which I'm very eager to hear. Thank you very much.
Thank you for your insightful introduction to the role of state aid in the digital context, and I'd like to encourage our audience to grasp this great opportunity to raise questions to this issue, which has a crucial role as regards the development and innovation dynamism in digital markets and connectivity issues, as well as we could see in the context of the gigabit connectivity. And I'd like to welcome our next presenter, András Pünkösdi. And first of all, I'd like to express my gratitude for all the time, effort put into the organization of this conference. Thank you very much. And as a presenter, I'd like to introduce you as an assistant professor at this university, at the European Law Department of Pázmány Law. But András has a coordinative and central role in the academic life as regards competition law, as he's participating as a researcher, of course, in the Competition Law Research Center at this university. But beyond this activity, he is also a research associate at the Institute of the Information Society at the Ludovika University of Public Service. He's a member of the Hungarian branch of the International Federation of European Law, and he's an editor of the Hungarian Competition Authorities journal titled Competition Mirror. Thank you very much, András, and please let us give an insight to the merger control issues, which are also in the focal point of the questions in the digital era. Thank you very much.
Thank you very much for this very kind presentation, Judith. And I'm about to start my presentation. If all the technical details are ready here, somehow it disappeared or does not want to start. happened here? Can you please help me? Otherwise, I will not be able to use my slides. Okay, thank you. So thank you very much once again, and I try to address some issues regarding the merger control, which is still kind of a debated topic, a hot topic regarding the proper how to give the proper answers to the challenges in the digital economy. We all know that one of the underlying bases of the challenges regarding to the merger control, proper merger control in the context of the digital economy is the highly dynamic nature of competition and also the highly dynamic natures of the market in the digital economy. Consequences for those characteristics of online markets, like the extreme return on scale, like the power and the significance of data in assessing the market power, also the data-driven feedback loops on the digital services and the network exteriors, of course, which creates very much an environment when the winner takes it all. And in spite of the fact that in the digital economy it's quite obvious that the data-driven force provides a competitive advantage, still it's not considered into the on its importance, not acknowledged by the assessment of the market power in the merger control regime of the European Commission and the European Court of Justice. Mainly, the Commission sees that data is possible to be bought by the undertakings, and we do have still the empirical evidences of the rising of some tech giants, and also one reason for this development from their on their behalf is that they're creating a ecosystem, a digital ecosystem that also provides, in certain cases, for possibility for vertical foreclosure and also taking an advantage from the significant amount of data they use. So, having experienced this reality, the policy papers suggest some new tendency in merger control, and also the national competition authorities searching the way how to deal with the merger controls in the digital economy. There was a joint memorandum issued by the Belgian, the French, and the Dutch competition authority, and reflecting mainly the issue that nascent firms are taken over by large technological companies, by the incumbents of the market. And that leads us to the claim, which is widely repeated, the under-enforcement claim in the merger control. And actually, if we look to the empirical evidences, then we see that in the numbers that there was over 400 acquisitions by the GAFAM companies between 2008 2008 and 2018, and none of them were blocked according to the Furman report. And we also know that vast majority of those target companies were actually quite young companies, which at the moment of which will result that at the moment of the takeover, it's not very easy to estimate whether they will develop for a successful company that will actually provide competitive constraint on the company, on the acquired company. And even though they are not necessarily killer acquisitions in the meaning that they will terminate the innovative solutions of the target, the tendency is that those innovative solutions that are developed by the startups are usually integrated to the ecosystem or integrated to the services of the acquiring companies. And we still can see the tendency that the mergers on the digital economy, the number of the mergers in the technical sector are just rising. There is a study which shows that after the pandemic period, still the numbers of the mergers accelerated. So some concluded to the statement that is very hard to avoid, the conclusion that under-enforcement happened in the digital markets, on the digital economy. Mike Volcker, the former chief economist of the Competition and Markets Authority, the watchdog, the UK watchdog, actually concludes that among those 500 and more mergers certainly has been false negatives. What does it mean? That those mergers that should have been blocked were not blocked, because to avoid the so-called false positive errors, that means that blocking mergers which should have been not been blocked. So on this basis of the cost error cost framework, Michael Volcker suggests that a more interventionist approach should be introduced in the regime of the merger control. Actually, yesterday we also heard a presentation that raised similar issues, whether merger control is performing its task in a right manner. However, there are some who do not agree with this statement of under-enforcement, and they claim that mainly of the predictability, the national competition authorities and even other watchdogs from an international perspective or supranational perspective, they did not really have other option that clear those mergers that are falling also to the mergers that may have also negative competitive effects and considered as false negative errors. And what are the recent trends to address this issue? We need to mention here the new legal act adopted on European level, the DMA. Article 12 actually provides an obligation for the gatekeepers that they have to notify the Commission of any intended concentration in the digital sector that provide any digital service even if it's not related to the core service of the platform, but for instance enable, I mean the target companies enable to collect data that will constitute this obligation on behalf of the gatekeeper to notify the concentration to the European Commission. And also there are those other obligations on the gatekeepers that somehow connected with this issue of the possibility of compete with the gatekeepers. And even after the DMA were or during the course of adopting the implementation, during the course of implementing the DMA, some member states still were claiming that it lacks in ambition. There was a letter together by the French, German, and Dutch minister responsible for the national economy that the DMA should go further with regard to accelerate the effectivity of the merger control regime. Here we also, among the recent trends, we need to refer to the notification system on European level, because some of the mergers were scrutinized according to those possibilities that the member state can ask the Commission to investigate certain merger if that would have fallen under the merger control scrutiny in the respective member state, or at least 3 member state sees that there is a significant effect on competition, then so there is this possibility to refer the transaction to the European Community, even if it does not fit with the community dimension. The third element in addressing the questions raised by the effectivity of merger control regime is the new system of the transaction, new system of scrutinizing the mergers by the under the transaction threshold. That actually was introduced firstly by Austria, and Germany do have also this development in its merger control regime. And in Austria, there are 3 conditions. If they are met, the watchdog can scrutinize the merger. If the combined worldwide turnover is above 300 million euro and the value of the transaction is above 200 million euro, and the target has a significant activity in Austria, then the national watchdog will have competence to investigate the relevant deal. However, that also constitutes some uncertainty both on the side of the authority and on the business, how to measure this transaction cost. And according to the explanatory note, at least all assets and other monetary value that the seller receives as a part of the transaction fall under the will constitute the element for calculating the number, and also the financial liabilities that the purchase takes over as part of the transaction. Still, it's not very easy to determine whether the transaction threshold is met or not. And having analyzed the challenges on merger control, I'd like to point out one decision which, according to my estimation at least, was a kind of pioneer decision, namely the decision by the Competition and Markets Authority, again by the CMA, which blocked the takeover of Giphy by Facebook, where this Giphy company were producing the visual facts that could contribute building the brand for some companies, and that was a highly innovative feature because that was the first time for a online service to monetize the online messaging services. And also we need to note that before that decision there was a market investigation carried out by the CMA, so they were very much familiar with the market, and actually full divestiture was decided by the CMA. What is important regarding to this decision is first and foremost, then the CMA concluded that the market definition is irrelevant in the course of estimating the effects of the merger. The CMA stated that there are a wide range of different products and offerings in the online markets, and new features and products are introduced regularly, and because of this it's highly difficult to define the precise boundaries of the market. So it was not part of the assessment, only to the extent is market definition important according to the CMA if it can contribute to the assessment of the effect of the merger. Otherwise, the real question what they are investigating is whether there is a possible competitive pressure, whether there is a possibility to constitute any constraint by the target. So that was the concept of dynamic competition by the CMA, and they also do the counterfactual, and in any case they decided to they concluded to the same decision. So now I have a signal that I do have 3 minutes left, so I need to again accelerate my speed, since the basic problem behind that ineffectiveness of merger control regime, or in other words, the under-enforcement in this regime, is whether how the theory of harm is established, namely the fact of the merger. And the two main ways to establish the theories of harm is one, the loss of potential competition, and the other is the loss of innovation. And with regard to the first one, it's quite hard to conclude, to constitute, to have this analysis on the framework of horizontal, in the case of horizontal merger, because it's in the digital economy is very unlikely that at the time of the takeover there is already a significant constraining influence by the target, or there is a significant likelihood that it would grow into an effective competitive force. And as a second condition, there is also a requirement that must not be sufficient number of other potential competitors. So those are established hardly in the digital economy, and that is why it's hard to establish on this basis the theory of harm. Regarding to the innovation, it's also quite a challenging task because it cannot be estimated or established by the competent authorities whether the acquirer company will close the innovative feature of the target or not. Actually, it's very much likely that it will continue and integrate it to its own system. So according to these points, still there is an ongoing discussion and some recommendations how these challenges should be addressed, and there is an ongoing claim, or at least a proposition to reverse the burden of proof, that the acquirer company should then establish that there is no detrimental effect of the transaction. This was also considered in the regime of the United States. Again, there is a question whether the conglomerate effect should be, the approach to the assessment of the conglomerate effect should be renewed, and basically the test, the substantive test of consumer warfare should be somehow modified by an effective competition test. So one last argument here, which is also coming from the academia, that the more adaptive burden of proof should be applied in assessing the effects of the merger. And actually this is the so-called balance of harm test, when also the quantification of the potential effects and the probability of each potential effect both would be considered by the authorities, and that could result in a balancing, in a more balanced approach to the alleged pro-competitive effects and the likely anti-competitive effects. So both the importance and the likelihood of the positive and negative effects in the same time would have been considered, and if the negative effect is estimated more likely than the aggregate negative effect would be estimated more likely, then the standard of proof should be reduced. Of course, there is a question of the legal certainty, and two conditions could address this question. If significant potential negative effects and the potential negative effects superior to the potential positive ones, then the assessment of the legal certainty could be maintained, and this situation actually would constitute a rebuttable presumption that could be challenged by the defendant, by the acquiring company. Thank you for your attention, and also looking forward to questions later on.
Thank you very much, András. And I'm in the privileged position to introduce you our next presenters, arriving from Indonesia. Hengi Widiantoro will start with the presentation, and Hieronymus Riti will join him. They are lecturers at the Faculty of Law at the Atmajaya Jakarta University. Please, the floor is yours.
Thank you very much. Good morning, ladies and gentlemen. I think the last speaker only gave a closing statement because many things had been said by the first speaker and the second speaker. Okay, in my paper by title Alleging and Abuse of Dominant Position, Impact of Telecom Industry Policy in Indonesia. So, my paper divided into two parts, and then first, problem background telecom industry policy in Indonesia, starting from law until government regulation. And then my colleague, Mr. Riti, would like to explain the dominant position in ethical perspective. What is the background? In my paper, we know that telecommunication is one of the most essential public services. In Indonesia, public services as a basic principle of the Constitution, because we know that public service are in the hands of all three branches of power: executive, legislative, and judicative. The obligate that all citizens should enjoy public service regardless of their social, cultural, or economic background. This has also been the basis for justifying the state's role in the telecom market, including the present digital market context. Yeah. You know that Indonesia telecom industry is an industry with a high market concentration. So, government policies must have positive impact. And then, government in Indonesia has large discretion because, you know, you look at government position in telecom industry as an operator and then as a regulator. Government is a dual function. So then has a large discretion on where and how telecom and their associated digital services might be built at the same time, okay, thus making the government have a dual function. I think as a regulation, you look at it, the government issued some legislation regulation, and then Article 71, Law Act 2023. The amount of tariff for telecommunication network operation and or telecommunication services operation are determined by telecommunication network operators and or telecommunication services based on formula determined by the central government. Stressing by the central government based on a formula determined the amount of tariff for telecommunication network operation. And then, based on Article 30, Government Regulation number 46, 2021, so look at it, the amount of tariffs for telecommunication network operation based on a formula determined by minister. Minister is an executive, same with central government, and then Minister of Communication and Informatics of Republic Indonesia. Okay, and as operator, the government of Indonesia is the majority shareholder with 52.9% in Telkom company. Look at that. Telkom company is one of the most big, yeah, I know that telecommunication industry in Indonesia. So that the government Indonesia is the majority shareholder with 52.9% and share, while the remaining 47.99% shares belong to public shareholders. Okay, and then PT Telkom Indonesia and then Telkom company is a state-owned information and communication technology enterprise and telecommunication network in Indonesia. So the largest telecommunication company in Indonesia is, once again, PT Telkom Indonesia, Telkom Indonesia company. So based on data from the Indonesian Stock Exchange, you look at it, and then PT Telkom is number 1. Okay. Based on this condition, the state has been pushing for extensive telecom services, including its society digital service. There are some reference on the ups of the state's role in the telecom market, and Indonesia is not alien to this. These ups and downs taught the state to be more attentive to the telecom sectors, and then the risk might be on excess of price and non-transparency, such as this risk might bring the problem of abuse of the dominant position. How we would assess an abuse of dominant position in telecom market where state has been active in it. On this, the look into abuse of dominant position would be weak in their down the road, when this should be a case against a dominant state. Juries and private sectors like should challenge the policies of Indonesia, because government policy is market intervention by the government. This is case in Indonesia. And then Mr. Riti, could you please perspective ethic in the dominant position in Indonesia, please.
From here or there? Yeah. Thank you very much, Mr. Hengki. Ladies and gentlemen, good morning. First of all, I would like to thank you, to all of you, for this valuable occasion. I have a good or a valuable opportunity to participate in this seminar or in this discussion. Actually, I am not an expert in competition law or in business law or even in telecommunication law. My subject is philosophy of law. You know what philosophy is, especially ethics and law. The first question is, what is actually ethics? Is it still important today, and why? I think it's better for us to discuss together rather than you raise a question, because philosophy is not about an answer, but it is a question that can be reasoned by all of us. Also, we cannot give a right answer to the question. Okay, ladies and gentlemen, I will not try to explain all of aspects of ethics in a very short time, so that I will just try to encourage you all here to discuss together about 3 kinds of ethics that, to my opinion, is very important to discuss relating to the topics that has been presented by Mr. Henke. There are several types of theoretical ethics, such as ethics of virtue, duty, situation, and so on. Likewise, with its properties, for example, descriptive, normative, and utilitarianistic ethic. And the other ethics is, first, the ethics of virtue, or Aristotelian ethics. Virtue, according to Aristotle, is arete, or success in carrying out the distinctive function of something. In addition, this ethics demands excellence, quality of behavior, of course, including the behavior of the states. The virtue referred to in this ethics is an ideal value, namely a kind of functional perfection and human personality. If this priority is related to business competition or to domination position of the government, then the business or the telecommunication world is said to have priority when the business is successfully carried out or fulfill its unique function. Products in the form of goods and services and so on are prioritized if they have good quality. Competition and telecommunication or domination as well is said to have primacy not only when it has taken place, but the perpetrators are human beings who have superior personal qualities and behavior. On the one hand, ethics is ideal because it requires the achievement of business goals and the running of the business, professionalism, and rationality. On the other hand, there are still problems. For example, failure to achieve goals. The business world is not functioning goals, and functions justify illegal methods, and so on. Another philosophical problem is when this ethics is no longer deals with right and wrong according to the standard of norms, but on the good and bad and sick inherent in something and the human person. Second, the ethics of obligation or regulatory ethics. This ethics is also known as deontological ethics. This ethics determines moral obligation or imperative that are absolutely binding without reserve. The goodness or badness of behavior is measured by whether or not the behavior conforms to the ethical principles or moral norms that apply. Therefore, this ethic is normative and evaluative. I think, to my opinion, we can discuss together the topics about the separation of regulation and ethics. For us in Indonesia, I think it is still important till today. We need not only regulation made by the government, but also ethics. It is not ethics when the government, if the government who is regulator and also have a function as a applicator, regulator, and operator. I think there would be a conflict of interest between the government as regulator that has made more regulations and the company, for example. Also with the society, for example. So here we need the role of the government not to involve too far in making the regulation. So I think from situational perspective, the government should make a distance between their function and the society. Let the society have their own freedom to decide whatsoever they feel better or good for themselves. So the function of regulation here is just to regulate the behavior of the society. So the role of the government as a dominant, position should be decreased so that the society can develop. It is a second, ethics. The third ethics of is obligation or regulatory ethics. Oh, I have mentioned this. I read it later. This ethics is also known as deontological ethics. This ethic determines moral obligation or imperative that are absolutely binding without reserve. The goodness or badness of behavior is measured by whether or not the behavior conforms to the ethical principle or moral norms that apply. Therefore, this ethic is normative and evaluative. With regard to business competition, for example, these ethics can be applied but intersect with the implementation of competition law norms. The origin of all mandatory and prohibited professions in law, number 5 of 1999, for example, is complied with, then the same time this ethics is manifested. In other words, both business and competition have moral values. And the last, situational ethics, as I have mentioned before, this is very important for the governments in determine the situation, what is good situations for the society and what the good situations for the government. I think this is all what I can present it today, just an addition to the presentation of Mr. Hengki, and I hope you can join together in discussion. So you can not only raise a question, but only give an answer, because ethics is only an answer, a question, sorry. Ethics is a question, like philosophy, it's not an answer. Okay, thank you very much.
Thank you very much. I'd like to invite our audience to raise the questions to this overarching flow of thoughts which reflected the complexity the competition law has to face. Please. Just a moment, you can receive the microphone.
Thank you. I have a bit of comment, essentially. One to Thiamer and second one to Andras. So if I look at the last slide of Thiamer, and it explained about...
Sorry,
yes?
We couldn't hear you.
Ah, okay. So if I can pay attention to last slide of Tihamer, it explained about IRIS, about the infrastructure of where the state aid info. So my comment and possibly the question is, if is it a typical IP argument on this, especially on the context of exception and limitation, especially in the field of culture and government? Is it IP argument which is needed to protect the argument of the state aid? And if so, then how this state aid can be justified in a way where this is already expansive, and for how long? So just question on IP, on the argument of IP, if am I correct on this? Second is to Andras. My comment is you explained about reversal of burden of proof. I'm always wary about this, but I will explain like this. So if I can compare with what Paul and Nuno explained yesterday on the plausible model or framework of between efficiency and moral hazard, and where this reversal burden of proof will be placed, will be positioned. Is it to support the argument for the efficiency or support the argument of prevention of moral hazard? So, thank you.
Thank you very much. I ask our panelists who would like to reflect first. Tihamer, are you here with us? And if you are available, please.
Sorry, I had some problem with my connection, but is it working now?
We can hear you.
Can you hear me, Judith?
Yeah, we can hear you.
Okay, I just had some issue with my connection. So I'm not sure if I correctly understood the comment question. By IP, I guess this refers to intellectual property. If it does, I have some problem with responding, because intellectual property concepts, approaches are quite alien to state aid control. It plays no role at all. What was important for the approval of that Irish project, that Ireland was able to persuade the Commission that this aid in the form of a tax credit was likely to promote cultural issues through video games. And of course, as you put it, it was limited in time. I don't know whether I mentioned it here, but I think this project will be running for about 2 years. So it's never forever. It's always an important condition that state aid must be proportionate, must be limited, also limited in time. So this is what I have to say to this question.
Thank you very much. Andras?
Yes, thank you very much for the question. I think I will also answer in a quick manner to summarize my answer, because we are a little bit running out of time. But in the assessment of the theory of harms, the question is whether there is a significant impediment of effective competition, basically. And during that assessment, the authority need to consider all the efficiency gains and the potential harms as well. And my point was that in doing so, the competition authorities tend to decide and allow and clear the mergers in order to do not have this harm, that we do not make this mistake, what we call false positive, to block a merger which should have been not blocked. And in this, and this resulted to have some errors that we call false negatives, that there are still mergers that should have been blocked. And for a more detailed approach was this kind of claim for balancing the harm.
Thank you very much. And again, I'm sorry to tell you that I have the pitiful obligation, but I'd like to invite you to join our speakers in the coffee break. And I can tell that this morning is we can spend in with the topic of complexity. We could have an insight in several layers. And I invite you to come back to our next panel, who will place new layers of complexity issues with cognitive biases, computational antitrust, and of course AI. So we'll meet in 10 minutes. And thank you very much for being present with us this morning panel.
So, ladies and gentlemen, we are about to continue our conference, and I have the great pleasure to introduce our panel members. Borbála Dömötörfi is a researcher of the Competition Law Research Center at Pázmány University. Zoltán Marosi from the DLA Piper, co-partner of the DLA Piper, and leading the competition law unit, and Attila Kőhalmi from the Hungarian Competition Authority, member of the Competition Council. And we are looking forward a very interesting topic today, what the technological challenges constitutes as a constraint on competition law. We will discuss that together with the respected panel members. And firstly, I'd like to ask Zoltán Marosi to deliver his presentation.
Thank you. Okay. Thank you very much, András, and thank you very much for the Competition Law Research Center for inviting me. First of all, I'd like to recall the context where I'm standing here. I will talk about the technology that is barely a few months or maybe barely a few years old, and I have the honor to speak at a university, which is a Catholic university, which represents the Catholic Church that has been there for 2,000 years, or more than 2,000 years. I think this is inspiring to be able to talk about something that is so new at an institution that is so renowned and so old. And I think this will give us some pause for thought when we're discussing such topics and novel issues. So first of all, yes, let me give you some overview about what I will talk about. My topic is ChatGPT, this new phenomenon, this generative artificial intelligence system. And what I'd like to talk to you a bit in the next approximately 20 minutes is ChatGPT's role and ChatGPT's connections with my field of area, my favorite subject, which is antitrust and competition law. And certainly, I will not talk about all of the possible interplays that are there between these two interesting subjects, but I chose three main topics that I think are key to understanding the challenges that are posed by these new products. First, I'll talk about anti-competitive agreements, in other words, sometimes cartels. Then I'll talk about abuses of a dominant position. In European law, this is Article 102 of the TFEU. And then I'll also talk a bit about unfair and misleading market practices. Certainly, this is not the totality of the issues, and I will also not discuss in detail how ChatGPT works, what this is. I think for those who are attendees here at the digital conference have already, I think, tried it, played with it, already know what this is, so we'll not go into details. Actually, I can recall Professor Láncosz's introduction at the very beginning of the conference, where she was even quoting ChatGPT and ChatGPT's opinion about the digital markets and competition law and the interplay. So I think you're already well versed into what this new technology is. So I'll restrict myself into talking about how this relates to our topics of today. So first of all, let's see how ChatGPT relates to anti-competitive agreements. What is the connection between the two? First of all, let me maybe just quickly remind ourselves of what anti-competitive agreements are. Certainly both European law, Hungarian law, and actually laws of most EU member states, and also a lot of the states around the world, prohibit agreements and conservative practices that have the object or the effect of the restriction of competition. These obviously include typical arrangements such as price fixing, market sharing, bid rigging. These are conducts that are condemned in I think all around the world as being harmful to the market. Now, how does ChatGPT or any kind of generative AI product comes in when we're talking about cartels? First of all, I think we can talk about maybe something that I termed as generative collusion. What does this mean? I think this is something that's been on competition law books for quite some time. People have been talking about robotic cartels or artificial intelligence cartels for quite some time. And I think the launching of ChatGPT and generative AI models have also possibly enhanced these possibilities, because certainly the ChatGPT has been trained on a large language model. What does a large language model mean? It means that it's been trained on loads of data, including text and including numbers and including figures and including information from various competitors. Now what happens if these chatbots would try to interact with each other, would not just learn their own data, but would learn from other chatbots? Would this mean they would perhaps start to communicate in some way? Would this mean that perhaps if ChatGPT knows the general terms and conditions of Google's Bard, which is the biggest competitor, it would then try to mimic that? Maybe it would then make suggestions for changes to the terms and conditions. Maybe it suggests changes for pricing. What does it mean? What does it mean for those who are operating and for those who are actually making ChatGPT work? What if they, in the end, realize that maybe it's better not to compete and rather it's better to cooperate and maybe, to be very blunt, to increase prices as opposed to cutting prices from each other? We don't know that yet, but I was just flagging the possibility. Another possibility is for what I termed as platform collusion, when it's not ChatGPT itself that is colluding with another chatbot, but rather that is companies that are colluding through ChatGPT or such large language models. What does it mean in this case? Again, as I said, ChatGPT and these models have been trained on large amounts of data. If I'm competitor A, I can use ChatGPT to access lots of things about the internet, ask lots of things, ask ChatGPT write poetry, but I can also ask, what is the current pricing model of my competitor? How does if I'm, let's say I'm a computer manufacturer, I can ask, how does my biggest manufacturer models its prices? What are its terms and conditions? When has it last time raised its price? Is it planning to raise its price? If there is any information in these chat models that are relevant, then I think there could be a possibility for these ChatGPTs or these large language models to function as platforms for possible collusion between competitors. And we all know that article under European law, platforms could also be liable in such situations. We call it the AC Treuhand liability under EU competition law. But in any case, you can call it contributors liability, where somebody who is not on a relevant market can also contribute to a cartel on a different market. This is what I think can also possibly happen to ChatGPT. But let's just not talk about bad things about, about these generative AI models and how they can facilitate collusion. But let's talk a bit about how they can be helpful to tackle possible collusion and possible cartel behavior. For example, ChatGPT can be a fantastic tool to generate compliance documents, to review compliance documents at any company. It can easily provide a down-rate manual for companies, for example, which so far has been produced only by lawyers. We can now ask ChatGPT to provide such a manual, and it would only be necessary for a lawyer to review that. So companies can access legal tools in a much easier fashion. Another clear possibility for artificial intelligence is that these chatbots can be fed with certain documents, and then we can ask ChatGPT or Google Bard to review these documents, for example, from the perspective of anti-competitive agreements. If I upload a company document to ChatGPT, I can ask whether that document contains any, let's say, any non-compete clauses, and whether these non-compete clauses are legal or illegal under European law or under national laws, and ChatGPT would be able to provide a response. Here I would certainly caution you that you must not rely on ChatGPT when it gives you a response, as I myself have tried giving ChatGPT competition law-related questions. Sometimes it gave close to correct answers, but sometimes it gave totally horrible and incorrect answers, which appeared to be totally acceptable or valuable. For example, I was asking it about the merger control thresholds in Hungary. When do I have to notify a merger in Hungary? And I found out that it gave an answer which really looked like a nice answer written in nice English using the competition law language, just simply the numbers and the conditions were totally false. So watch out with when you ask these products, but certainly in the future this can be one of the areas for development. And finally, an interesting thought: if you've been following this generative AI arena, you may have seen that several high-profile scientists have been warning about the dangers of AI, and therefore they have been asking and saying that the further development of AI should actually be stopped, and they said at least for 6 months we should be waiting for further development of AI, and we should be checking how does it work, how does it affect society, what are its conditions. And certainly this sounds, I think, reasonable, or this is something that can be debated, but for a competition lawyer, for competitors, meaning AI developers, to stop developing that together and agreeing on stopping the development, for me as a competition lawyer, that doesn't sound very good. That sounds like something that sometimes you can even call a cartel, stopping development. If you stop development in the cement industry of new cement plants or new cement products, that would clearly be a cartel where Attila and his colleagues would immediately be very interested in what's going on in that market. Now for the platform market, for the AI market, certainly that is something that you have to consider. At the same time, because this does indeed sound like a possible anti-competitive arrangement, at the same time, you must not forget that there are also exceptions from the general rule of anti-competitive agreements, the prohibition. There is a possibility for exemption, and there is a possibility to argue that we're talking about certain ancillary restraints here, something that is necessary for the development of a system in compliance with the relevant rules. And here I think what was very instructive with one of the Indonesian colleagues was expressing was ethical rules, ethics. And I think AI ethics is a very, very important subject in itself. And I think developing an ethical AI, and so posing the development of AI in order to have a really ethical AI, could be a possible ancillary restraint and could be a reason how we can explain such a pause in development. Certainly all up for questions. I haven't seen any official documents or decisions in this respect, but I think these are all interesting questions to ponder. Then another big topic is certainly abuse of dominance. Obviously, again, in a number of member states, it is prohibited for any company who has grown big to become dominant to abuse such position of dominance. Classic examples are refusal to supply, various options of discrimination. Nowadays, when you're talking about, big tech, Google, Facebook, preferencing your own product as opposed to services of another company, these are all possibilities for abuse of dominance. How does ChatGPT or generative AI come into play? First, certainly in order to check whether a company is possibly dominant, you have to see what is the relevant market. We competition lawyers have to start with this exercise first to see what is the arena of competition, to see who's exercising competitive pressure on a given company. In order to have a response on this, just as Professor Lantos, I was also asking ChatGPT. You can see the response on the screen. I certainly don't want to just simply read it, but as you can see, ChatGPT itself has an opinion on its own product market and its own geographic market. Well, in terms of the product market, it appears that these are natural language processing models. And in terms of the geographic market, it's possibly worldwide or maybe EEA-wide. In respect of the geographic market, I was just flagging maybe one question here, which is these are language models. So these are certainly using typically the English language, but are available also in other languages. So, for example, I tried asking ChatGPT a question in Hungarian, and it provided a sufficiently acceptable Hungarian response. But certainly the question is based on this, can we somehow differentiate between markets based on language, or maybe based on different product types? As I understand, there is a Chinese version now, not for ChatGPT, but rather for generative AI. This is called Baidu. Baidu has this Ernie product. I understand the Russians have developed their own product, which is GigaChat, apparently. I have to admit I haven't tried any of these, but certainly it's interesting to see how much they compete. If they are a product, let's say, based on Russian language, do they compete at all with ChatGPT or other products? That's an interesting phenomenon. And then also it's interesting to see that it's not just the market for generative intelligence that is relevant, but again, in competition law, we always look at the entire supply chain, where vertically we can differentiate between various markets. And so, for example, if you talk about a product that is being developed, then in this case, it's ChatGPT, and then it's various uses. So, for example, if there is a bank or if there is an insurance company that uses a chatbot, which is based on ChatGPT, then it's a derivative market. Then that is a derivative product. Actually, I heard that we lawyers at law firms have started using not just ChatGPT, but different versions of the product for our own legal services. One of them is called, for example, Harvey. So this is interesting how ChatGPT will allow certain interoperability with its own products and services, i.e. will ChatGPT allow access to its own language model services to third parties, or whether it starts to restrict that, or whether it starts to ask for certain fees for that. Maybe it asks for higher fees from some, lower fees from others. Does that amount to discrimination? These are all interesting open questions. Especially the competitive nature of these markets is especially important because as I said, it's a new technology. These are new, as András has already mentioned, that digital markets, these are nascent markets, new markets, innovative markets, fast-changing markets. So the classic Chicago school type of people would say, this is the area where regulation or any kind of intervention is clearly not warranted. Just let the markets arrange it for themselves. This is new. This is how markets should work. These are new products, new development. Consumers can decide which they want. This is not the place for competition authorities to even look into. At the same time, if you look a bit more closely, you can see that these markets are not, well, of course they are competitive, but there are some interesting features that make you, again, pause a bit. First of all, you can see that there are really significant barriers to entry to these markets. So if I want to make a new natural language product, I wouldn't be able to do that. Maybe even if I know coding and if I'm a really good IT guy, I wouldn't be able to enter the market where ChatGPT is. Why? Because these are, for example, one of the reasons is that these products are using huge language models where you need to train these products. And to train that, you really need power, costs, energy, time, which I, as a new startup IT company, certainly wouldn't have. Then again, it's a big question how can I access the data that is there? Is it something that is giving them some kind of a strong competitive advantage? Is it a market where there are strong network effects? ChatGPT is famous for increasing its consumer base to 100 million in a few months. Does that mean it has network effects, just like Facebook had in the old days, about 10 years ago, or these other free paid models were available? So what does it mean to have these strong network effects, does it mean that these markets, are prone to tipping, which means that these markets can easily be dominated basically by one player, and then we'll see the same situation as we've had with Facebook 10 years ago, when we said, oh, it's so interesting, these social media platforms, LinkedIn, Facebook, or Twitter, all these other platforms, and everybody was saying, hands off, I mean, these are really interesting models. But in the end, somehow it turned out that in the end, for search engines, it was only Google that had, and maintained more than 90% market share. Interesting questions to ponder. And finally, just a few sentences about about unfair and misleading market practices, which are again banned in the EU. One of the biggest portfolio for the Hungarian Competition Authority, for example, is the use of these application of these unfair market practices. Typical examples are market-leading statements, statements of that, for example, you don't have to pay a cost for something. You'll hear about an interesting case from Attila very soon about dark patterns. What do they mean? Question is, to what extent these are applicable to AI markets? One of the key questions is transparency, and this is already included in the European Union's draft AI Act, that if you are an artificial intelligence model, then and you can interact with consumers, then you have to inform consumers that you are an AI model. That is, the responses that you're receiving are not coming from a natural person, but rather from artificial intelligence. That's step one. The question for me is, should we maybe even use this in the unfair competition world? For example, in the Unfair Commercial Practices Directive, there is a blacklist which talks about practices that are always absolutely prohibited. Can we say that if an AI model does not label itself as an AI model, fails to model itself as an AI model, so consumers are misled, should we also include this in the blacklist? Should we also say that not showing that you're using an AI model is also blacklisted? I think it's a question that we'll see later. Then also another big, again, I should only ask questions and not give you a good response, is the issue of liability. Even if you're using a language model to produce commercials, to produce pictures, to produce text, and then you're using it in your own commercials, infomercials, your TV spots, who is liable then if there is a mistake in that language, in that picture, if it infringes the copyright, if it misleads you, if it contains incorrect information? Very, very interesting question again. And then finally, I have a +1 issue on the new regulatory approaches. I thought it's important just to list the main initiatives in this field, especially in the EU, which I think the highlight is certainly the European Union's AI Act, which has just been accepted in the Parliament in terms of its text. So these regulatory tools are there, and the big question for me is to what extent we want to use these and our old regulatory tools, meaning the European Commission's powers and the national competition authorities' powers to check, for example, abuses of dominant positions or mergers, to what extent we want to use these old tools to tackle artificial intelligence. Because some people are saying that what happens in artificial intelligence is just a replay of what happened with Facebook and the others 10 years ago. It's the same, just quicker, so we have to intervene now, because we have to avoid those failures for which we are writing the new laws, the new Digital Markets Act, Digital Services Act. So if we don't act now, in 10 years we have to write a new digital, some kind of AI competition act, which will already be too late. So one aspect is we should act now. But again, the other part of the coin, or the other side of the coin, is that these are nascent markets, these are competitive markets, these are totally different tools, these are new toys. We have to wait until the markets develop themselves, and only intervene if we see that there is an actual distortion. I leave you the floor to this debate. Maybe you want to debate it here, maybe after that in the coffee break, but I think it's a fascinating subject, and I don't think anybody really has the answers. But maybe that is why we have a 2,000-year institution here to help us and inspire and think about that. With that, I thank you very much for your attention once again, and I'm certainly open to questions.
Thank you very much, Zoltan, for this brilliant and thought-provoking speak and talk on generative AIs and ChatGPT. Certainly we will have some questions and highly important questions to answer. But now I'd like to give the floor and ask Attila to deliver his presentation that also has some similar implications affecting the human and the human brain, probably. So please, Attila, the floor is yours.
Thank you very much. First of all, of course, I would like to thank you, my friend András, for the invitation. Not just because this is what we say regularly in this situation, but about 20 years ago I was sitting within these walls of the university, and I didn't think that I would be here and give a speech. So thank you very much. It's a really great pleasure. So, first of all, this is the title. Maybe it's a click hunter title, but I have a question for the audience. How many of us use Booking.com? Please raise up your hand. Yeah, thank you very much. So maybe you know why this title. If not, I try to explain, and it will be my mistake if I couldn't. So, only a few spaces left for this presentation. This is the title. Before the decision, I would like to give a very short overview, because maybe not exactly know the Hungarian competition authorities procedures. So I try to explain who are we and what is our procedure. And after the behavior economics, which is, I think, it's the most important field of economic nowadays, and about the decision, and the main question, why is it unlawful, and a judicial review, and maybe after a very short conclusion. So first of all, our authority, we have 4 areas of competence: agreements restricting competition, cartels, abuse of market dominance, unfair commercial practices like this case, Booking case, and merger control. Our procedure has 2 or 3 phases. It depends on the client. So the first one is investigation. Investigation, we begin ex officio or by complaint, and during the investigation, case handlers deal with the case, and there is a figure, maybe it's more easier to understand. So case handlers, after the investigation, write case handlers reports and submitted the report and also the case file to the Competition Council, and the chairman of the Competition Council signed for 3 or 5 members acting Competition Council the file. And after a check of the case handlers report, the Competition Council, acting Competition Council, write SO, preliminary assessment of the case, and there is an opportunity, of course, for the clients to comment our SO, and if the clients would like to, there will be a oral hearing, and after the oral hearing, there is the situation that the Competition Council make a decision, and after the decision, of course, there is opportunity for the clients to appeal our decision. Now there was a change, and now there is only one level, a first system, the Metropolitan Court, where is the appeal, but after there are many extraordinary appealing for the clients. So behavior economics. Behavior economics studies the effects of psychological, cognitive, emotional, cultural, and social factors in the decision, not just individuals, consumers, but also the institutions. And also studies how these decisions deviate from those implemented by classical economic theory like Chicago School, including how market decisions are made and the mechanism that drive public opinion. I don't know that there is another economic field which in the last 4 decades won more Nobel Prizes than behavioral economics. Minimum 3 economists won the Nobel Prizes in the last 4 decades: Herbert Simon, Daniel Kahneman. Daniel Kahneman is important in this case because he was the first who deal with FOMO effects, which is the main idea of this case, and also won Nobel Prizes Richard Thaler, 2017. Behavioral economics important not just because of the marketing, but also the politics, because this is a kind of tool that can they use to deviate, to manipulate the people. So neuromarketing, which is a main part of the behavioral economics, it's a brand new study, but the main idea of neuromarketing is more than 100 years ago. So Hugo Münsterberg in 1913, so before the Great War, before the First World War, write this sentence. Hugo Münsterberg was a very famous US psychologist who was born in Germany, but he's a really capitalism Czech psychologist. So he wrote, businessmen will eventually realize that customers are merely bundles of mental states and that the mind is a mechanism that we can effect with the same accuracy with which we control a machine in a factory. So it's very hard to read this sentence because it means our brain is like a machine in a factory. So there are tools which we can manipulate the brain and decision making. So it's very hard to read. So neuromarketing is a commercial marketing communication field that applies neuropsychology to market research and advertising, studying consumers' sensory motor, cognitive and effective response to marketing stimuli. So neuromarketing, what is the benefit? The potential benefits to use neuromarketing. It will be more efficient and effective marketing campaigns and strategies, and also less product and campaign failures, and ultimately, and this is I think the main idea, to manipulation of the real needs and wants of people to suit to needs and wants of marketing interest. So this is a tool to manipulate our brain and to explain what is we want to, because this will be my idea, buy, for instance, in a shop. So cognitive biases, which is I think it's the main tool of neuromarketing. It's a very difficult and complex figure here. We can see the brain, and there are many opportunities to manipulate the decision-making process. So what is the term? Cognitive biases is a systematic pattern of deviation from norm or rationality in judgment. Individuals create their own subjective reality from their perception of the input. An individual's construction of reality, not the object input, may dictate their behavior in the world. So maybe have you seen the movie Inception? It's a typical this kind of tool, but not in a businessman sleep, but it's just another kind of tools without to a journey, to a real journey to a brain. So FOMO, maybe I remembered Kahneman, the scientist who won also in 2002 Nobel Prize. He was the first scientist who write this FOMO effect. FOMO effect is a part of the cognitive bias, defined as the fear experienced by individuals when faced with the thought that they might miss out on a social occasion, a new experience, a profitable investment, or a satisfying event, brackets, a hotels or a holidays. So this is the main idea of what we follow in our case. Fearing is a very important feeling of the humans. Here we are in the Catholic University, so maybe, yeah, it's free to mention that in the Bible there are 365 times the word fear. So we have fearing for every day. Every day it's very hard. Maybe this is the reason that why it's so successful to use this tool in the marketing, because we are humans and we have many fear. And this is the act why it's so successful. And this is the reason that Jesus said so many times that fear not. I don't know how many times in the New Testament, but many. So now here we are, the decision. First of all, there is a sentence. Maybe everybody knows that behind every great successful man there is a woman. But I think it's very important to mention that behind every great successful decision, there are good case handlers. So thank you very much for your conscientious and accurate work. Hegyesi Nagy Éva, Kolondja Dóra, Otlakán Johanna, and Perge László. Thank you very much. So the decision. The Acting Competition Council, first of all, determinate infringement because finds that Booking.com has engaged in unfair, aggressive commercial practices by publishing urgent information of psychological pressure nature in relation to accommodation offers available on the Booking website and also in the Booking app. What was the consequence and sanctions? So not just determined the infringement, but Acting Competition Council also imposed a fine. It was the biggest in the history of the Hungarian Competition Authority history, the biggest UCP cases fine, 2.5 billion Hungarian forint, which is approximately 7.5 million US dollars. And the second part of the sanctions consequence was, of course, prohibits Booking from the unlawful acting and orders it to provide the GVH with detailed and credible written evidence that in all its commercial practices it doesn't display the urgent messages like and so on, shortage claims. Just in brackets, now we have a procedure, follow-up investigation, how Booking fulfilled this decision, so how it's ongoing. And the main question, why is it unlawful? What was the legal basis? The EU UCP directive, Unfair Commercial Practice Directive, is the same like the Hungarian law. We implemented one-on-one, so it's absolutely the same. What is the question? What is the aggressive? Because we determined this conduct was aggressive commercial practice. What is commercial? What is aggressive commercial practice? Use of physical force or undue influence. It significantly impair the average consumer's freedom of choice with regard to the product and thereby causes him to take a transactional decision that is the main idea, he wouldn't have taken otherwise. So there is a decision by the consumers what he didn't want to, and this was the tool, the aggressive conduct which caused this decision. So the ninth paragraph showed that there are many circumstances which are very important in an assessment. For instance, the timing, location, nature, perspective. So there is many factors what we have to check. And the facts. In connection with the, so what was the facts in this case? In connection with the accommodation offers available on the Booking website, and not just the website, but also the application, the undertaking adopted pressure selling tactics at each stage of accommodation search and book process, not just one occasion, one website, but every step by step, was many pressure selling tactics. So it was a strategy by the Booking, not just one occasion. This took the term they use attention grabbing information. For instance, circling in color, especially red, because red is also mean of forbidden, and this is the more highlighted color. Pop-up windows, font size, or other characteristics. And of course, the message. The message which used was, for instance, 32 more people are also watching in this time, this website, this accommodation. One person in considering booking this accommodation right now. Highly sought after. Booked 70 times in the last 24 hours. Missed it. So these messages with the pressure selling tactics gave consumers the impression that the accommodation they were viewing was subject to high demand and limited. So it's a feeling in our mind that I have to make a decision very fast because there is a situation that it's a hurry, that maybe somebody else will book this accommodation, but I want to. So this is the reason why we said that it is aggressive. And this practice is to exert, of course, psychology pressure and disrupts the consumer's decision-making process, as it subconsciously evokes emotions and fears in consumers that if they do not book the accommodation as soon as possible, they may lose out on it. So this is the FOMO effect, what I mentioned. This is the tool that the Booking use to manipulate the consumers. And all this distorts the consumer's transaction and this decision. So here we are, that now know what is the story, but what was the evidences. So maybe the most important evidence was an internal report. I think it's very important because it's a kind of a queen of the proof that Booking wrote in an internal report. We know it's because that time UK was the member of the European Union, and we had, or maybe we has now also a good relationship with the CMA, and we have information about this report, and that was the reason why Booking had to give for us this report. So the title is a report for understanding persuasion messages, which include that this practice, this FOMO practice, increases the conversion rate. What is conversion rate? It's how many web visitors, searchers, will not just surfing on the website booking.com, but book accommodation. So it's very important for the Booking because of the commission. So every hotel's accommodation pay commission after the book, after the consumer's book. So yeah, this is the financial background. And there was also a GVH, a Hungarian Competition Authority's market analysis, which was supported with a market research survey, and we had, of course, the behavioral economic studies also like evidence. So just a pair of websites. Here we are with red color informations. Only 2 rooms is free. Missed it. Very highly sought after. Yeah, missed it. Only 2 rooms in the last 24 hours. 7 times booked here. It's the first page if you search. And also there are now here just 1, 3, 4 times. 3 times, sorry. And here we are 2 or 3 times, 4 times. And the next here we are, the data. Yeah, here 1, 2, 3, and here we are the pay, and also there are many, and only one. So that's all. So this was the reason why we made this decision. And of course, Booking appealed against our decision. And I mentioned that now there is only one first instance, the Metropolitan Court. Metropolitan Court upheld our decision, and the decision, the sentence was almost the same like our decision, just a pair of paragraphs. 93, Booking commercial practice already suggested during the search contained urgent messages that pervaded the entire booking process and put the consumers in a contest. Or the next one, Booking bombard consumers with messages of an urgent nature, which were capable of creating a feeling in the consumers that he missed out on an important opportunity. So here we are, the FOMO effect. He finds himself in a losing position, thereby making a thoughtless decision and making a decision immediately without further information. So it's a thoughtless decision. And maybe, I don't know which, maybe the courier used the word rush decision here. So, yeah. Okay, so the courier decision was almost the same. There is a big difference that courier upheld the legal basis of the fine, but annuls the amount of the fine, and this instructs the court of first instance for a new procedure and a new decision, but only in the amount of fine. So now we won the legal basis of the fine of the story, the case, but the first instance, the Metropolitan Court, had to, about the courier's instruction, make a new decision about the fine. And there was another part of, because Booking used every opportunity in the Hungarian law system. So there was a constitutional court case, but the constitutional court rejects Booking complaint, doesn't raise the doubt of unconstitutionally that's significantly influenced the judicial decision, so reject the complaint, and also this courier as a legal uniformity court reject Booking's legal uniformity complaint because no discrepancy can be established between the judgment challenged by the complaint and the decision cited in the complaint in the legal issues raised. And just a very short conclusion, end of my slides. So 100 years ago or more ago, put the gun to our head to do something what we don't want to do. But nowadays, this online world is more sophisticated, more refined, and they have a tool because of behavior economics and neuromarketing. They can manipulate our brain without being noticed, realized that it was. So this is the neuromarketing. And what can do average consumer in this situation? I think there is only one opportunity to know these tools, to realize that now there is the techniques what they want to do against me. Thank you very much.
Thank you very much, Attila, for his excellent presentation, to giving some insights how online communication might influence some consumer decisions, and it's good to raise awareness about this. And thank you very much again for the presentation. And now I turn to Borbála and asking her to introduce us to the concept of computational antitrust.
So thank you very much, András, for the opportunity to be here, and I am short, sorry. So thank you very much for the opportunity to talk here about these interesting topics, I hope not only for me. I had been also a student of this university several years ago. I just don't plan to admit the exact number of that years. Sorry for that. So yeah, so it's really nice to be here. I will try to keep it short, especially because my topic is somewhat special. Now I am a researcher of the Computational Law Research Center, but not so long time ago I had been a lawyer. So I would like to start this presentation with a disclaimer that this topic, computational antitrust, is still in very early phase, and it is subject to a lot of research. So my goal with this my presentation is to just give an overview, some thought-provoking ideas, probably to open the field for some debates, and it might be somewhat provocative. So the table of content, it is just to summarize, give an outline of my presentation. First, I will just give some initial thoughts about what is computational law, and after about computational antitrust, because computational antitrust is the subfield of computational law, and some evolution of web and antitrust in a comparative way and visual way. And after, I will talk about the benefits and challenges of computational antitrust in general, and finally, I will talk about the special challenges for the Central Eastern European region. So what is computational law? It's a branch of legal informatics concerned with the mechanization of legal analysis. These thoughts about codifying law and creating more certainty and predictability about the legal outcomes is not a new idea. It actually came back to Leibniz and Bentham, and even the codification waves in the 19th and 18th century were outlined by this, but now the digital technologies give a new life to these aspirations. And several computational tools are used now in the world and also in the field of law. Legal tech is a very hot topic now all over Europe and all over the world, I would say. And the use of data mining, machine learning, deep learning techniques, large language models, and so on and so forth. Even legal design, that is one of my favorite, is now really a hot topic. And I also highlighted some future challenges, which are even in an earlier stage, like the VR, the metaverse, Web3, the blockchain technologies, and their application in law. I mean, in antitrust, especially because they can solve the same purpose by decentralization, quantum computing. So there is a lot to come, I would say. There are some predictions. I think everybody might heard about Richard Susskind, who is kind of the founding father of these thoughts about the technology and law and their interaction. And he sees technology as a path to better justice. I think not everybody agrees with him, but I actually do. And there are some predictions from Thibaut Streppel, who is a professor at Stanford University, that computational methods will first supplement the functioning of our legal system and will end up taking over a large part of it. So a lot of things which are now done by lawyers, they consider that it will be done by technology. But in my view, this will create new field for legal work and more complex legal tasks. And how it relates to computational antitrust, I mean, how these computational tools can be used in antitrust, depends on the computational tool, a lot of different ways. I already mentioned the potential role in blockchain, in decentralization, but today I would like to focus more on the data analytics and AI techniques, because now it is a really hot topic, and also because I find it really interesting. So actually, the Codex Center of Stanford already created this antitrust API. Everybody can go on the website and try it himself or herself. It is kind of automating antitrust compliance. There are questions that what I can do, what I cannot. It's really interesting. So I encourage everybody to try this tool. And this is not an independent effort. There was also Giovanna Mastarotto and Ashwin Ittu who created a study about whether AI can replace the FTC, and they used the K-means clustering to and the other data science method to see this, and they reached the conclusion that actually it couldn't replace the FTC, but it can supplement its work and make it better in several ways. So it's interesting. So now about the evolutionary timeline and why I think that computational antitrust is the future and it is necessary. I compared here the history of web and the history of antitrust. We can see that the history of web is much shorter. Antitrust started earlier, but we reached more or less the same time, the same level, the web-free and the antitrust-free. So web-free is the blockchain technology and the decentralized internet, semantic web, etc. But there was before the Web 1 in the beginning of the 1990s, which was only readable, I would say. And then the Web 2, which is the interactive, like I can post on social media, just to not mention any market player. And now the decentralization, NFTs, smart contracts, etc. And in case of antitrust, it was in the US in 1890, the Sherman Act, in Europe a bit later with the Treaty of Rome. This was the textual interpretation, I would say. After the more economic approach and Chicago School was the antitrust 2.0, and now the focus to the technologies and tools, both in content and as a tool. This I call the antitrust 3.0, and they seem to catch up around 2020, both in the web and in antitrust. So, and why I think it is necessary, it leads us to the benefits of computational antitrust. Because if the world is so data-driven, AI-driven, digital transformation, technological revolution, etc., we can call it different ways, then the antitrust community, the enforcers, policymakers, lawyers, and everybody just cannot be left behind. If we try to use traditional techniques for a world which is more advanced, then we will be left behind. So that's why I think that computational antitrust is really necessary. And it can improve the enforcement several different ways by I just mentioned some ideas like machine learning to help to identify anti-competitive patterns in the world, and NLP for document screening. It can shorten the time and investment that authorities invest in the investigations. And the analytics capabilities are really increased by the modern data science techniques, and also very important, the faster merger screening. I think in Hungary it is already very good. The decisions are really fast in the merger field, but it can be in more complex cases improved by the data science techniques and other techniques. So what are the other benefits? Like for the companies, higher level of predictability, legal certainty. They can assume the outcome or the whether they can do something. So a higher level of compliance, let's say, probably it's the best way to say it. The policy making can become better because this analytics technique can create better certainty also about first the retrospective way that we can analyze better the former decisions of the competition authorities and the courts, and after also we can create better predictions for the future by these technologies. And after the benefits, we have to talk about the challenges, which can be different by nature. And it's really interesting that Schreppel identifies that the challenges are more human challenges than technology-related challenges, because machines don't create the problem, but how people adapt to these machines, they can create the problem. And I strongly agree with this. And I highlighted one specific challenge, which is kind of collaboration. I can really see this as a problem. Sorry for the typo. I was improving a little bit my slides, but I sent it too late. So sorry for that. Between the coders and the lawyers and the data scientists, the designers, it is not easy, the communication. Sometimes I find it that way. And I think this is really important. And also the adoption of different type of business models in the legal world, it might create further challenges. So also on the side of the computer scientists, data scientists, it can be challenging for the competition authority to hire them because they might need different kind of incentives than they are used to deal with. And these were just some of the challenges of computational antitrust in general, I mean even in the big jurisdiction. And now I would like to turn our focus to the Central Eastern European region, because it is my main goal to talk about this. And this region, because there are a lot of quite small countries in size with different legal system, different tradition, different culture, and especially very different languages. From a computational point of view, it can create several challenges. And also that there was an IMF research paper about how AI can create a great divergence between different countries, I mean the most developed countries and let's say least fortunate countries, that, can create a gap and widen the gap even more between the rich and the less rich. And because it shifts the investments towards the countries which are already in a more advanced stage. And also if there are not, the traditional factors of production in economics are, let's say, just simplifying labor and capital, and if we add labor, capital plus robots, then this can create also divergence because the robots are applied generally in the most developed countries and where are the wages so high that it is worse to replace the workers by the robots. In countries where the return on investment for the robot cannot be so high because the wages are lower in general, this can hinder the application of robots and hinder, on the other hand, the development. And also the data harmonization and policy coordination in the region, I think, and the lack of it. I mean, in antitrust, it is quite well harmonized compared to other areas, but it is still not perfect, and for the computation it has to be really exact. So to be codifiable and be coded in a programming language, it has to be really exact. So it has to be a really strong harmonization, I would say. And experiences in other sectors, I highlighted it some problems with small countries, artists, and not mainstream artists with YouTube and Spotify, that they don't get recommended. So there is a problem with the recommendation engine system. There is a great book about this, Data Feminism, which is not about feminism, but about how the biggest manipulate the data world and things like that. So it gives really interesting insights about that. And I think it also that there is a kind of, we wouldn't say it is an economies of scale, but probably the closest to this in this way. So a network effect, of course. And we should also take into account the different legal systems, and not only the different legal system, but the different publication system, data availability, customs, market characteristics, etc. So it will be a real challenge. And after I divided into 4 groups the different challenges that this region is facing in the age of AI, which is first of all the technology side, but it is mostly related to the data availability. If there is already more data generated in English, for example, than in Hungarian, just to mention an example. And this kind of advanced AI tool really need a lot of data, really a lot of data to train the model well. And also the limited access to the technology and the reliance on the external AI system, which not perfectly adapts to the needs of these countries. And from the legal side, there are some regulatory barriers. I mean, this is not only for the Central Eastern European region probably, but generally in Europe, that some of our, let's say just an example, data privacy rules can hinder the development of AI. And also this different jurisdiction, I don't want to talk about this too much because I already mentioned that, so this can be challenging from this point of view. And the investment, like the investment flows to the more developed areas, like when when it is very risky a project, they like to do it in startups, but after they just buy the startup. So this is one thing. The cost is very high, and the return of investment to develop something really complex AI tool for a small language, it is probably just not enough to do so. And also the entrepreneurship culture of these countries is influenced by the former regimes and probably not so advanced, like for example in some parts of Western Europe or in the US. And this also counts. And there is also the human side, which is probably the most important, and not only the language barriers, but the cultural differences between these countries, and also the cultural preservation, because it is real value, the uniqueness of the cultures, and how to preserve it in the age of AI, when, how to say, it is kind of English-dominated world, and this culture also dominates. And the shortage of experts, this also relates to the really good IT professionals leaving the countries. So that was my main ideas about these topics, and for some recommendations, just to close with something positive and not just with the challenges. I think that the enhancement of innovation and the improvement of an entrepreneurial culture is really important, just like the cooperation, collaboration, even if it is strange to say it in an antitrust conference, and the communication between the different countries and experts. So that was what I intended to.
Thank you very much, Borbála, for this excellent presentation and this overview on computational antitrust. And now I turn to the audience, either online or being in present, whether they have question to ask for the panel members. Yes, please. Could you please help me with the microphone, passing the microphone?
Excuse me, sir. As we know that, according to Mr. Sultan, that the presence of ChatGPT affect in many fields, and I think it is also affecting competition. So I will to know more about the effect. According Mr. Sultan, is the ChatGPT bring the change of the point of view about market structure or behavior of business actors? Okay, thank you.
Thank you very much for the question. I think this is something that I think nobody really knows the final answer. I think we are all speculating about this. The market structure for artificial AI, so generative AI models, that is something where what we can see is that certainly ChatGPT was one of the first, or actually the first model that most people used and saw and talked about, which is not owned, but to some extent controlled by Microsoft. At the same time, we have now Google's Bard, which is another tech giant. Bard is not available in Hungary, but is available in the US and some other countries. And there are some other, although smaller, models as well. So you can already see that at least there are two big players on the market. So at least there, you can see that the market is not monopolistic. But you really don't know if this will develop in a competitive manner meaning there will be more players and we'll see some strong competition and strong innovation in these markets, or it will simply be that there will be 1, 2, maybe 3 players altogether, and then we'll end up in a situation where we have to fear that there is maybe not a monopoly, but maybe there is perhaps collective dominance or some kind of a strange situation where competition authorities would need to intervene in one way or another. And I think for me, or I think for a lot of people, the big question is whether this intervention should be done now because of the lessons we learned from 10 years ago from the Facebook and for the GAFAM situation, let's put it this way, or we should really wait because this is something totally different and we should just hold back, see how the market develops. Maybe it will be competitive, maybe it won't, and then we have to deal with that later. Or we should learn the lessons of what happened 10 years ago and try to act now. I really don't have the philosopher's stone in my hand. I really honestly don't know what's the best response. What I see is that all countries are trying to do some strong regulation. So the EU has the EU AI Act. In the UK, the Competition and Markets Authority has just initiated the so-called initial review of these generative AI models. So everybody is trying to do something, but nobody really knows what to do and exactly how. So I think that's a key question. And I think there will be conferences on this, and I imagine there will be. This is something that will come up every half year, month, as a big question.
Thank you. There was another question. Please.
It seems that artificial AI is a famous topic because I have a question for it as well. So we heard the concerns and the possibilities from a point of a lawyer, but I would like to have some insights from the competition authority as well. Whether the authority has already internal discussions on how to probably use ChatGPT or other type of artificial intelligence during their investigations, other work, whether you have concerns as from the authority or not. Because as a lawyer, I already sense that in some point, maybe the competition authority will come and seize my ChatGPT correspondence during a dawn raid, but I don't know if that's a possibility.
It's a good question. Maybe I am the only man who didn't use ChatGPT in this room, so I don't know the answer. Maybe just the time will answer for us. So good questions. That's all that I can see now.
So more questions than answers, yes, regarding these challenging effects, chilling effects of technology. But there is another question, please, Paul.
Well, one short question actually. What's your guess? What will be the relevant market regarding ChatGPT? In Bing, it's already incorporated into search. As far as I understand, yesterday's announcements from Google. They also incorporated it into search. So what will be the relevant market? Search, because then it's more difficult to see the tipping point and other arguments, or this will be a separate market?
Question is open.
If I may start, I already addressed this issue of product market and geographic market in my presentation. So maybe there is an answer engine market that's developing. What I think if I can just, I know I won't be giving a proper response to your question, but maybe just one interesting aspect that I want to draw or draw your attention here is that while previously we were always talking about Google's dominance in the search engine market, it will really be interesting that, and we thought that, oh well, this is happening for 10 years, nobody can overthrow Google. It is maybe the situation that maybe somebody has found something that can overthrow or effectively challenge Google. And while Bing in the past as a search engine was not capable of really exerting strong competitive pressure on Google, this may now subject to change. And so we can see that technology can really change markets. And this, I think it's exciting to see that the technological development is changing what a market is and who are the main players on that market.
Thank you. I'm looking all around whether there is another question. Yes, if not, then I'd like you thank again for the excellent contribution to this highly challenging topic, and probably we are just starting to discuss on these issues, and I really hope that we will have the possibility to continue our discussion together on how technology affects human brain and in general the well-being of the individual. So thank you very much again for your contribution, and we will now have only a short technical break, and this way we can catch up with the timeline. So in 5 minutes we will continue with the next panel. So thank you very much again.
Our first speaker will be Fanny Orossi, who is a PhD student at our faculty, but also a practitioner for a few years, now working in Brussels, and she will be speaking on e-commerce in the 21st century and the antitrust challenges. So I give the floor to Fanny.
Thank you very much. I will have to share my presentation. I'm not sure if this will work, but I'm trying.
We can see it.
Can you see it now?
Yes.
Perfect. Thank you very much. So I have to admit that I'm not in Brussels right now, but I'm still in Europe. So it's still a transatlantic connection. I'm happy to be here, and I would like to thank you all for the opportunity and for organizing this conference. I'm very happy to present here today. As Pal already said, I'm a research, I'm in my research as a PhD candidate at Pázmány Péter Catholic University, and my research concentrates on the digital industry and also the effects of digitalization on EU competition law and competition policy. I think that e-commerce is a very important part of the digital industry, and this is why I also included this into my research. And to be honest, I'm very glad that I opted for this topic, and I'm very glad that I went into the digital when I started my PhD studies, because I think that there is a very good enforcement and regulatory activity in this area, and also the academia is very active in that. And there's a lot of food for thought, and there are things to write about, which is great. And if we turn to e-commerce, from the 1990s, there was a very huge boost of this industry with the internet and also with the first web browser. And since then, few years has passed, and the participation in e-commerce has become inevitable, in my opinion. In 2023, already 20.8% of the purchases are expected to take place online, and this number will only grow with the years passing by. The impact of COVID-19 was huge in this area, and a lot of stores which only had a brick and mortar presence decided to opt for having an online presence as well. And I think what is really interesting is that nowadays we see that companies are starting off from their online presence only to opening up some showrooms, because this can, to some extent, make them more trustful for consumers. And what is even more interesting, I think, is the question of manufacturers becoming basically distributors of their own products, causing disruptions for distributors who for many years thought that their business was untouchable. And dual distribution is a question that is, I think, sometimes very problematic from a business perspective if you are looking at the distributor side of this. And how can you be present in e-commerce? You can have your own website. That's the very basic, I think. You can use online marketplaces. Such marketplaces are Amazon. Maybe this is the one that most people know, but we have some other marketplaces as well. For example, Amag is also very known in Europe, and especially in Hungary or Romania. Some businesses opt for using e-commerce platforms like Shopify, This is another concept where you can have your own e-commerce shop, but they will do everything for you. So this is different from, for example, Amazon, where you would have the platform of Amazon using that as a way to sell your products, but the branding would be an Amazon brand. Or if you use Shopify, which is only a way of selling your products with your brand. There's also social commerce, which is quite new. Social commerce is when people, consumers decide to purchase their products directly from Instagram, for example, or Facebook. So you wouldn't leave the platform itself because they have built into the platform a possibility to buy products. This is also a very big constraint on e-commerce today. And mobile commerce is also a new notion, meaning that a lot of people are now purchasing products from their mobile phones. So they would not even open up a laptop or a notebook or anything, but they would just buy their products from their mobile phone. And another question is the regulation, the future regulation of Facebook Marketplace, for example, which is becoming bigger and bigger with every day passing by, where people are selling their products, their second-hand products, without anyone, for example, looking at those products, whether they are truthful or not, whether the reviews are true or not. And I think this will be probably the next niche market where regulation will be necessary. During my research, I categorized the types of sectoral challenges that e-commerce faces today. And I think that probably the most important one for us is the regulatory and the enforcement perspective of these challenges. But there are also some economic market challenges that I think we have already heard of today. For example, AI and ChatGPT are becoming more important than ever in the life of e-commerce. If you look at this list of regulatory challenges, I just listed all the things I could think of which could have an effect on e-commerce and which already have an effect on e-commerce. So in the last couple of years, we had the GDPR. More stringent data protection rules are present in the EU. This is different from the US, and for platforms acting and having their seats in the US, for example, or in Asia, coming to the EU and having a presence in the EU will also mean that they will have to respect the data protection rules of the European Union. I think this is an important factor to consider because there are high fines based on the GDPR. And also in Hungary, our data protection authority can be quite active. And also in other countries, for example, in Ireland, data protection authority is very active in this area. Then there is digital single market strategy of the EU. This contains several directives, regulations, and one of the aims of the digital single market strategy is to give better access to goods and services via e-commerce. And this is also a harmonization tool in the EU. Then we can think about the geo-blocking as well, meaning that if you are present in one country, you have to make it possible for someone purchasing your product from another country to order that product from there. And you cannot make a differentiation based on where this person is sitting behind a computer. And I think that this is also causing some problems if we think about, for example, pricing criteria. How do you price your product? And targeted pricing, intelligent pricing based on geo-blocking can also be a problem. There is also the parcel delivery services, which the EU is trying to harmonize. And pricing information has to be provided to national regulatory authorities. Digital contracts for Europe is another area of harmonization. Digital content and services and the sale of goods are also covered by this. And what the EU is trying to do is to have conformity in these rules. The Digital Services Act and the Digital Markets Act are the two most important laws, I think, in the last couple of years. And these two have become buzzwords of 2022. And also still today, they are our buzzwords, and we keep thinking about it, and clients keep asking about them. Digital Services Act covers intermediary services. So this could be an e-commerce platform, and they try to target dark patterns and illegal content. For example, counterfeited products could be sold on many of these platforms. If you think about eBay, for example, they had issues and they had cases because of that. People kept selling counterfeited products, for example, perfumes. And the question is the liability. Who is going to be liable for that? Is it eBay? Is it the person selling that product? Can we even find that person? So this is another question I think that we'll have to answer based on the Digital Services Act. The Digital Markets Act has a scope which only covers gatekeeper platforms. I think we heard a lot about the Digital Markets Act yesterday. It also came up today already. So I'm not gonna talk about that in detail now. And then there's the Omnibus Directive. This was also a buzzword in the last year. This covers online B2C commerce, which is business to consumers. And what they amended is already, the list is already tremendous. The most interesting one, I think, was the Price Indications Directive, because what the EU decided to do is to come up with a 30 days rule for campaigns, meaning that if you have a campaign and you decide to have a sale, you cannot price your product just randomly and say that, oh, there's a sale. You have to have a basis of comparison for the consumers, which has to be the lowest price in the last 30 days. The transparency in ranking and search results is also an important question here. How can you be compliant with this? How can you always have transparency in that? And my question here is, will consumers care even? Because if someone is a competition lawyer or is interested in competition law and consumer protection, we will check it for fun. But I'm not sure if this will be something that many people will do. Fake reviews and endorsements cannot be posted anymore. This is also quite challenging task, I think, for e-commerce businesses, because reviewing all the things that are posted on an e-commerce platform is a task that maybe cannot be done by human work only. So I think AI will come in here, and we'll have to be trained to, for example, review these short reviews and endorsements on our websites. Information will have to be provided when personalized pricing is applied. This, I think, especially, for example, with airplane tickets, will be something that is interesting. I see that also in my personal experience when I am shopping online, also in different areas. And I never saw before some platform maybe saying that they have used personalized pricing based on my preferences. And another thing is the review of the vertical block exemption regulation and also the new vertical guidelines. we can see how we are moving forward and how we are moving away from protecting the online presence. There is no protection for online sales anymore as before. We had in the EU, this has changed because they realized, based on the review of the guidelines and also the regulation, and based on the stakeholders' ideas, that this is not necessary anymore because the online sales are becoming more important than brick and mortar. And also the agreements of hybrid platforms, meaning, for example, Amazon, will be outside of the safe harbor of the vertical block exemption regulation. This is something that attention has to be paid to. In Hungary, we also have influencer marketing rules, and the Hungarian Competition Authority is quite active and is providing guidance in that regard, which I think is great. Many people, and I hear that from other competition lawyers in other countries, and also from regulators, that they don't really know how to tackle influencers and how to deal with this issue. Here also liability, I think, is important, because we are never really sure about what are in the contracts behind an influencer, or sometimes they don't even have contracts in the background, which I think is problematic. And I think that there will be some questions here coming up in the future. And another area in which the Hungarian Competition Authority has been active is the sustainability questions and the green claims of companies. This is also gaining importance in e-commerce, especially with the deliveries. These companies have to deliver their orders all the time. And this is, we could say, that not necessarily sustainable. And even though that they try to claim that they are green and they are CO2 neutral, sometimes these claims are not substantiated enough. And for consumers, like, for example, the Gen Z, which is something that we cannot just not think of, sustainability is going to be an area, and I think something that they will think about when they are conducting their online shopping. Another area is the enforcement. I listed only a few cases here. So the Hungarian Competition Authority had 3 cases, I think, which are important. The AMAC case, the ALSA case, and the WISH case. These were all based on unfair commercial practices. And as you can see, all of these cases had some sort of commitments or compensation involved. This also brings compliance into question. How can you comply with all these commitments? And this is also something that we can see in the European Commission's Amazon Marketplace, Buybox, and Prime case. These were different cases, but then the Commission decided to merge them into one case and close it with commitments. In the Amazon Marketplace and the Buybox case as well, the use of data had great importance, and how the hybrid role of Amazon played a role in them using this data for their own good, and how they were preferencing their own products, their own sales, compared to third parties. This is very similar to what we have seen in the Google Shopping case, based on which we can now say that self-preferencing could be a sui generis abuse of dominance, but this case is still on appeal. In the Amazon case, what we can see is that the commitments tried to target the use of data, the equal treatment, and non-discrimination. this will have to be implemented in the next 5 and 7 years, which is quite a long time. And it will be monitored by a trustee. And also Amazon will have to pay a fine if not complying with these commitments. We'll see how this will go and what is the future of that. But I think that it is very important to have a very stringent compliance for these platforms, because we can see that enforcement is coming in and is targeting these dark patterns. Also, for example, urging messages and also pricing and discount practices that these platforms have. The market challenges, I listed some of them here. I'm of course not an economist or a marketing specialist, but I can already see by reading that the social commerce is something that is a market constraint on these general e-commerce platforms that we know today. And it could be that the market will change a lot in the next 5 years, and we'll only purchase everything that we want to from Instagram or Facebook. Not sure that this should happen, but we don't know. The role of AI and the role of ChatGPT is something that is gaining also great importance today. ChatGPT could be used to provide product descriptions or to be the customer service, or it could be used to have intelligent pricing on our platforms. If we are shopping online today, we can already see that they use chatbots for their customer service. The first step in general is going to be a chatbot answering our question if they can, and then only can we go to a natural person, which is something that will be, I think, even more used with the role of ChatGPT. I think that we are competing now with time, and also in deliveries. This is something that we can see, and the fastest and the cheapest delivery could win a lot of times. And when we are trying to shop online, this is, I think, most of the time, one of the most important things that we are looking at, because today we want everything now, and we want it in the best condition, but also we don't want to wait for it. If we have to wait 2 weeks, maybe we will just leave our basket there. Greenwashing and sustainability is also a market challenge of today. And I think the biggest challenge is going to be Gen Z, because they have different expectations. They grew up with basically all the phones, and they want more sustainable world. And I think that e-commerce platforms still have to deal with that. And how can we tackle these challenges from the perspective of the businesses? We can see that there is harmonization on EU level, that's for sure. And this has been coming in the last 10, 20 years. We've seen that the EU is trying to work on that. And I think that in the last 5 years, with the digital single market strategy, this has become one of the most important strategies. I think that there has to be focus on compliance, if possible, compliance by design for these platforms. And they also have to constantly monitor and train their personnel as well, because these challenges are only going to become harder. And they also have to comply with all the commitments that they make with the authorities. I think that for now, we have still room to comply, and still we have room to settle. But in a few years, we will face huge fines from all the authorities around the EU. And there are some new use cases as well for AI. For example, what I've been already talking about is how to monitor websites for fake reviews. I think AI and ChatGPT and all the brothers and sisters of ChatGPT could be used for that. Cooperation with authorities will be important on all levels, also on national and also on EU level. On the EU level, DigiComp and DigiConnect will monitor, for example, together the Digital Markets Act. It's not only going to be DigiComp anymore. On the national level, we have the data protection authorities, we have the competition authorities in the EU, and we also have consumer protection. Consumer protection can be enforced on different levels as well. So that's also something we have to look out for. And I think that we are racing really with technology and time, and also with consumer preferences of the new generation. And with all the regulation that we've been just mentioning now, we can see that companies face huge challenges today, and they really have to be more on the compliance side instead of facing abuse cases or UCPD cases, because this costs a lot of money and a lot of time, and it only brings with itself all the commitments that we make and that we have to comply with later. And I would like to thank you all for your time and for your attention. And I'm really interested in what do you think about these issues.
Thank you so much for the, again, thought-provoking issues. I haven't tried yet shopping with, there is something called Auto GPT, like it's an agent AI, so automating all the tasks. You can gather information, automatically sending news to you automatically. You just have to give the right prompts, and it's widely available. So it's very interesting to see all these challenges which we face. Another challenge is or will be shown by Max Huffman from Indiana University. I've read recently a very good book, How Antitrust Law Failed Workers, and there were very, very thought-provoking issues there, comparing consumer welfare loss in traditional antitrust law and the harm to workers for not enforcing antitrust law in a specific way. So we will now listen to labor and antitrust issues in the gig economy. Thank you so much in advance.
And thank you, Paul. I'm trying to share the screen, but I'm being prevented. I wonder if we have other screen share that is currently going.
Fanny, can you exit your sharing, terminate sharing?
There we go. Okay.
It worked, right?
Yes.
Yes, I now have access. Thank you. And thank you again, Paul, for the kind introduction, and thank you to Andras for the invitation to participate. This, I think, is an excellent program. The last time I participated in what I think was a previous version of the same program at Pozmani was 5 years ago, and the primary discussion point was the GDPR. And it feels like an entire lifetime ago, both in terms of all the things that have happened in the world since, but also in terms of all of the regulation and the change that's taken place in the various marketplaces that we're talking about. And so I think this is there is need for more and more of these kind of programs, and I'm very glad to participate. I'm going to try to be respectful of time. This is my one complaint, Andras, is you put me just before lunch on the second day of the program. I know that stomachs are rumbling and so on, so I will try to be respectful of time as I proceed here. But I want to talk about general antitrust treatment of labor. I want to talk about some active questions that I think exist in this space. And I want to then sort of finish with talking about particular issues in the gig economy, which I think is a sort of a unique organizational structure that leads to unique problems in the labor in the labor-employer relationship, in particular as it applies to competition law. So just a couple notes about labor in general, which I think helps to frame what I'm talking about. And before I do this, one other thing I'm going to say. I'm going to put this through the lens of U.S. antitrust law. I recognize I was at a conference in Europe, even though I myself am sitting in the U.S., but in recent work with Maria Schmidt-Kessen at Central European University, we have more or less come to the conclusion that most of these broad concepts can be applied equally. The actual specific application and the pace of adoption of these various ideas is different, of course, in different sides of the Atlantic and different places in the globe. But that said, I think that we can use U.S. law as a lens, and it's nonetheless informative. So some broad concepts that I think are going to help to understand what we're talking about here. So labor is an input into manufacturing. At some level of abstraction, it's no different from any other input. Labor is like other supplies that you inject into the process, and that helps to explain how the economics operates and why it is that labor ends up presenting competition issues. Workers are a lot like consumers in this important way. They will lack bargaining power relative to the employers. If you think about a supply chain with workers at the top and employers in the middle and consumers at the bottom, you would expect to see much more concentration in the middle, which produces bargaining power disparities in both directions. The employers have greater bargaining power with regard to the workers. They also have greater bargaining power with respect to the consumers. And so you might want to interject legal protections in both directions to protect the laborers, also to protect the consumers. So here is a big difference vis-a-vis consumer markets. Labor is, everywhere that I have studied, heavily regulated, including minimum wage rules, maximum hours rules, requirements on the kind of benefits that we produce, pensions and otherwise, workplace safety laws. And so a lot of what you might want to achieve through competition policy is already being achieved through regulation. And I think that's an important thing to observe as we go forward here. You also have the problem in the labor space, and this relates to the idea of the regulation. Some of these other laws, whether it is a law that incentivizes unionization or otherwise, may conflict with the antitrust laws, and you may have to resolve that conflict in some fashion and decide which of these is going to dominate when you have a conflict. And then the last one here, which I think is clear, is the gig economy and the way in which the worker-employer relationship works is fundamentally different than what we thought about growing up, where you get a job and you stay with that job for many years, working a certain number of hours per week. So the basic model of labor markets I've tried to outline here, which is, this is incredibly abstract, but it sort of depicts what we said in the last slide. You have this disorganized, diffuse group of workers who lack bargaining power if operating individually. They're competing against each other, driving wages and benefits down. The producers, by contrast, might be a monopoly. They might be an oligopoly. They might be, sort of otherwise relatively concentrated. And then at the consumer side, once again, you have relative diffusion and the same problem of differences in bargaining power disparities that arise as a result of that. So the economic impact of this is interesting. Paul points out that there's a lot of writing recently that our consumer welfare focus that we've taken, at least in the U.S. antitrust, is a little more subtle on the European side. But the consumer focus that we rely on might seem to subordinate worker interests, because you can imagine a circumstance in which employers exerting bargaining power vis-a-vis labor will lower the costs for the employers and therefore lower the cost of the products they sell to consumers. And there's some intuitive appeal to that notion. There is some economic theory that supports a different analysis. If you were to have a monopsony, of course, being a buyer-side monopoly, or an oligopsony, right? That's our concentrated employer marketplace that is negotiating with a diffuse group of workers. Because of the upward sloping supply curve, the effort by the monopsonist employer to drive down the cost of labor is going to reduce the amount of labor hired, because workers are not going to keep participating in the workforce, at least in that particular market or that particular industry or that particular geography, as the price of labor, that is the wages and other benefits, go down. As you drive down the inputs, the amount of labor that is being consumed, you will reduce the manufacturing output commensurately, or at least in some related fashion. And that reduction in manufacturing output will then lead to reduction in sales to consumers, which can also to an increase in price to consumers. This stands on its head the idea that driving down the labor wage rates will benefit the consumers. In fact, if this analysis holds, this is not my analysis. This comes from Harrison and Blair and others who have studied monopsony effects in marketplaces. If this analysis holds, then harms in labor markets can lead to harms in consumer markets. And conversely, if we can correct for these harms in the labor markets, we can also correct for consumer harms, and that may unpack some of this conflict that you might otherwise think exists between the two. Another way of looking at this is a consumer-focused antitrust policy can also operate to the benefit of workers. So if that's right, one cure you might look for is to organize the workers and give them bargaining power to drive wages and benefits back to a market clearing level, back to the equilibrium point. And if you were to do that, you would then increase, once again, the output from the producers, and that would benefit the consumers as well. This, by the way, is maybe the best justification for an exemption from antitrust for labor unions, because we've now given an incentive for the workers to band together and push their salaries and benefits back to some level that is going to be a consumer-friendly output level. In other words, we are creating countervailing market power. So the effects of this, labor unions can create countervailing power. They can drive these wages and benefits back to a market clearing level. If, in the absence of the union, the market is warped by monopsony effects. This explains why we have exemptions for labor unions in both the US and the EU. It is also the case that if you don't have a union, you might otherwise regulate to achieve the same impact. You might drive wages or terms of employment back to some equilibrium level, and once again achieve the same benefit. You will bring workers back to the workforce. You will increase the output. The consumers will benefit. That, of course, has all the problems that we have with regulation, and you can debate whether we like the free market approach of negotiation between the union and the employers, or whether you prefer the regulated approach of government-imposed terms of employment. And the third approach that you can do to mitigate these harms would be to break up the monopsony or oligopsony employers to increase the competition for workers, and that may return some bargaining power as well. That raises questions of whether this is the right thing to do as a matter of market oversight. It also raises the question of whether you have legal rules that allows you to break up monopsonies and oligopsonies, which I think is inconsistent, at least with the U.S. approach here, to dealing with concentrated markets. This is meant to summarize some of these general problems that you have in the context of trying to fix labor market dislocations. Unionization can be a cure. Difficulty, you need an exemption for unionization. If you don't have the exemption, a union is just a cartel of workers. And we'll talk about that further here in a minute. You can regulate wages, terms, hours of employment. One big problem with that applies to employees, and not all workers are employees. When we get to the gig economy here in a moment, we'll see why that's a real problem. And the third is the breakup question. But there's a serious question about whether that is consistent with legal rules, et cetera, right? The honest monopsony would not be a legitimate target for a breakup effort. You'd have to be finding somebody who achieved monopsony power through some inappropriate conduct for that to work. Okay, so let's move to the gig economy and talk about unique challenges here. One commonly discussed problem, and I know this is something that has been advanced more aggressively on the EU side. We're seeing slow inroads into this on the US side as well. The classic view of a gig worker is that this is not an employee. This is a contractor, and if so, employment protections don't apply. It is interesting to try to follow the US case law developing in this space. The primary gig firms, and the one that is the best known, of course, U.S. side is Uber, Lyft to a lesser extent, right? Another ride sharing enterprise, have been spending literally tens of millions of dollars to avoid finding themselves liable in court for violating employment law. What they're doing is whenever somebody sues and says we're an employee, we need employment protections, Uber is willing to pay off that lawsuit to the tune of tens of millions of dollars in order to avoid a ruling that says that there is employment here. And that's been going on for some time, and which suggests to me that we actually may have a set of legal rules that would find employee status, but our particular litigation system makes that hard to uncover those. If you don't have employees, first of all, you don't get employment protections. But the second, you're also not allowed to engage in labor unionization efforts. There was an effort driven by the city of Seattle, Washington, several years back, where they tried to unionize within the city all of the rideshare workers. This went up through the courts to the Court of Appeals and the Federal Court of Appeals in the Ninth Circuit. And the court concludes that this is not exempt from antitrust law, and ultimately the case settled. And then there's a third notion, which is how we even conceive of the relationship between the gig platform and the workers. The gig firms will frequently say, we don't hire anybody. We don't even contract with people. We sell services to them. And you have your own contract between the rider and the driver. And so that frame may change the way we think about this. So circling back to some like foundational ideas of what the gig economy marketplace is all about, an early paper with Mark Anderson, we found sort of 7 factors that seem to exist in all gig economy firms. The first 3 I list here because they're the most relevant. The other 4 are interesting, but not relevant to this talk. But you'll note there, so that the 3 players, that's a well understood phenomenon, right? The platform sits between the consumers and the suppliers. We talked already about the atomism. We have these diffuse markets of workers and diffuse markets of consumers, where they don't have bargaining power, but we have a concentrated market in the middle made up by the platforms. The third one I put in red because I question it now. At the time we wrote this paper, there was a sense that if you drove for Uber, you didn't engage in specialized investment. You already had a car, and you just put someone in your spare seat as you were driving, and it made entry and exit really easy. I think the reality is, it turns out gig economy marketplaces tend to incentivize a lot of specialized investment in order to participate, which means workers end up being locked in and they can't leave easily. And you also raise the question, is the platform an input provider into supplier-consumer transactions, or is the platform actually engaged in employment? And I think once you start questioning those 2 things, it changes the way we think about how we should be applying the law to these gig economy marketplaces. So we have on the left side of this slide, what the platforms have been arguing forever is their status. They say, we sell a product. You buy the product, which is the software and the algorithm and everything else, and you use that to provide rideshare services in your own independent business. If you think about it that way, this is just a classic vertical supply chain, and the platform is just an input provider into this supply chain. Nobody's employing anybody under that picture. The suppliers are independent contractors doing their own thing. The better understanding, based on what we know about the way these marketplaces operate in the modern day, is that the platform is actually sitting there in the middle and driving the entire transaction. The suppliers are inputs into the platform's work, and the consumers are the purchasers of the platform's services. If that's the case, then it raises the possibility those suppliers are actually employees and not just people running their own independent businesses. This picture has been supported by various discussions, both in the scholarship and in courts and also among regulators. A decision from 2020, the Glovo case out of the Supreme Court in Spain, gave some weight to the idea that the platform is actually bringing these people on as service providers instead of selling a product to these to the drivers. A similar breakdown of early conceptions to the reality, right? If you look at what was going on at the advent of the sharing economy, there was a sense that people would use these sharing economy platforms to share, that's where the word comes from, the notion of a sharing economy, their unused assets, what Mark Anderson and I have called the fallow assets. For example, if I'm driving to work already and I have an extra seat in my car, I can sell you that seat for not very much money, and we're both better off. You have a cheap ride to work, and I have a little bit extra money from driving the car, from driving you to work. And the result is, and Uber takes some money in the middle. And if that's right, if that picture is right, you don't really have unique harms to be concerned about. What it turns out is taking place, and this is after many years of development of the gig economy. We've now even changed the name. We no longer say sharing very much, because really what we have is people devote themselves to this kind of work. People will quit their other job. People will move, perhaps even emigrate to move somewhere else. They will buy new assets. They'll buy a new car in order to be able to participate in this thing, which means they are stuck in the sharing economy work. And if that's the case, and this is an intriguing thing, which is better depicted graphically, but I'll try to describe it. Instead of the upward sloping supply curve that we talked about earlier in the slide deck, where workers, as the price of labor goes up, will work more, and the price of labor goes down, will work less. A locked-in worker may face a downward sloping supply curve. As the earnings per hour decrease, that worker will work more hours, because they must cover the costs of their enterprise, in other words, pay for the car that they just bought to drive for Uber, and they must also cover all their necessities. They have to buy food and pay for rent and everything else. And if that's correct, you're not going to result in it, you're not going to produce a tolerable equilibrium. You can't have a circumstance with a downward sloping supply curve where we could possibly accept the outcome of that marketplace. If that's right, then you may need to think about some other method of dealing with this. We have efforts to treat workers, gig economy workers, as employees. And if we can't do that, maybe there is some third category. This is, again, something that's been progressed fairly rapidly in Europe, in various member states, less so in the US. This notion of a third category approach treats economically dependent contractors as subject to the same kind of protections you might give to employees. It's an early paper by Harris and Kruger, two economists, to talk about this. And some US states, cities and states have jumped on this a little bit and said, you may not be employees, but we're going to regulate the terms of your work anyway as contractors in ride sharing and otherwise. The state of Washington in the US has done this. New York City has done this, treating Uber drivers like taxi cab drivers. California has tried a similar thing. It's had mixed success because their effort to change the definition of an employee has been hung up in courts and otherwise. But we're seeing states generally move on to the idea that we should broaden the notion of employment to include these gig economy workers. This starts to raise questions where antitrust is going to get involved, because so far we've been talking about regulating the employment contract. I don't want to, time being short, I don't want to dig into this with the depth that we could. But one thing to note is, you might ask, can antitrust serve gig worker interests? Can we use antitrust effectively to break up some of the bargaining power disparity that we were talking about in the gig economy? There are hurdles to that. Fundamentally, what is the violation that we're concerned about? Because if all we have is an innocent monopsonist, we don't have a basis, at least in US law, for breaking up that monopsonist. The negative operation, can we prevent antitrust from impeding worker self-help? And here we have the problem, which we talked about again earlier, where if you collectivize your efforts, you risk being treated as a cartel. And so we need to have an exception from this. And for fallow assets workers, this may work, but for the locked-in workers, it turns out that you end up having limitations on your ability to give exemptions from antitrust. I'm going to skip past a couple of other thoughts. I'm going to flag one last thing about this here. So Mark Anderson and I make this argument in 2021. We argue that if your gig economy worker might organize, your gig economy worker is the fallow assets kind. This is not the person locked in. This is the person who's legitimately using the car as an underused asset that they're going to sell for gain. We should allow these people to organize, because these are people with an upward sloping supply curve. And if they can organize, they can drive the cost of their work back up to an equilibrium level. The difficulty is these are not the people that really need protection. And the people that really need protection, the locked-in workers, need to be protected through classic employment law regulation, where we would impose minimum wages and otherwise to support their work. Handful of papers that discuss many of these different ideas. I've cited only my own and ones I've written with others, but we cite other work in here as well, and I'm happy to share this slide if further investigation in this is interesting. I appreciate, again, being involved in the conversation, and I look forward to any discussion that may follow.
Thank you for the thought-provoking questions. Any questions from the audience? No? Then I have two questions, if you allow me. Just short. You touched mainly these points. I'm just trying to make sure whether I understood your arguments correctly. So, gig workers might not want to be protected. There is an argument for that. Like look at the Section 22 referendum in California. So sometimes, do you think? I guess your answer. But do you think then, if they don't want protection, they should be protected? And the second argument is also related to this one, that the reclassification of gig workers to employees, if we do that, or if we create a special category for that, then we have to balance. There will be a necessary clash in certain cases between consumer welfare, like lower prices, and the interest of the reclassified employees. So how do you do the balancing there? Is there a hierarchy of interests, or you just do the rule of reason test, what you suggested?
So thanks for that, Paul. And briefly to give flesh to your point about Proposition 22. So California is a mess the way the state makes laws. But what happened was that California tried, as a matter of regular legislative process, to redefine the notion of employee to include gig workers. So far, this makes sense. This is consistent with everything I was just saying. However, there was a citizens referendum, which is Proposition 22. In California, if people want to get together and sign a paper, a petition, they can then seek to change the law through that process. And the citizens referendum overruled the California law and thus reversed the redefinition, which made them gig workers, not employees again. Your question asks whether if people don't want to be, subject to, the employee definition, if they want not, to opt out of this protection, should they be allowed to? My sense is that probably doesn't fairly describe what took place. Uber and Lyft dumped a huge amount of money into the Proposition 22. And what it really reflects is the success of organized corporate lobbying efforts in order to change the law. And so I think that's an important reality check. More to that, though, I guess I think probably not. I don't think you get to opt out, because I think that we're talking about the beneficiaries of these protections as being the marketplace in general and everything that flows from that. And so this really speaks to your second question. I don't think that there is necessarily a tension between the worker and the consumer here, because I think if we're talking about driving the price of labor down so low that workers are not participating in the marketplace, the effect of that will be to limit the options available for consumers. And one way to test this, I haven't done this rigorously, but I will only note, Uber was a very attractive product before the pandemic. Because the prices were relatively low and the car and the rides were readily available. The pandemic changed a lot of things, but after the pandemic, we have not seen drivers come back in the same number. And the result is the prices for riding in Uber are much higher and the experience riding in Uber is much less pleasant. That to me is an example of, if we don't sufficiently protect the employees, we don't make working sufficiently attractive as an enterprise, the consumer harm then flows from that as well. And so because I don't see those two things in tension, my sense is you don't have to decide how to reconcile them. So I suppose those are the responses, but thank you, Paul.
Thank you. Yes, we have one more question.
Just one.
Just a second.
This one. Oh.
Now it works.
In one of the explanations, there is a suggestion about harmonization. So it's not working.
Maybe the microphone is not working. Can you do it here?
Now, can you hear me?
Yes.
Just comment to Fanny. You put a kind of comment to harmonization in EU-wide. And yesterday we have also explanation from Cem about rules and standard as a way to harmonize. So do you have a specific suggestions on the e-commerce, whether it could be in the form of rules or in the form of standard, just to put some of question. Thank you.
Thank you for the question. So if I understand you correctly, your question is whether we can use standards or use rules instead. I think that regulation and rules are necessary for practices to be able to become standards at the end. And I think that overall in the EU, regulation is more important in general. So I would opt for that. But I'm not sure if I'm answering your question. Maybe if, sorry. Can you still hear me?
Yes, we can.
Okay. So yeah, I would say that it's going to be regulation based on our experience in Europe, and also what is important is case law. But in case of, for example, unfair commercial practices in the EU, it's more on a national basis that we have the cases. So I would say that from a case law perspective, it's really hard to standardize these practices because we, in general, don't have European case law on that level. From a competition law perspective, it's more important, I think, to look at the standard practices that we have from the case law as well. But from a consumer protection perspective, and I think in the EU, we have a lot of issues from that because we have all sorts of regulation now and all sorts of directives, but sometimes it's still not harmonized on an EU level. So if you have practices that you would use in different countries, it can have a different regulatory perspective also in different countries. And I think if you look at, for example, the cases that we have with the Hungarian Competition Authority, in Hungary, it's highly important to be compliant with competition and also with consumer protection rules, because the Hungarian Competition Authority has a very strong practice of consumer protection, but this is not the case, for example, in many other European countries. So, for example, in Poland, in Italy, the Competition Authority has competence to act, but not in other countries. I would say that it's both. It's regulation. It's also standards, practices becoming standards, and also case law that you have to look at. And I hope that I answered your question. And please, if you have any follow-up, let me know.
Okay, thank you. No more questions. Thank you for the speakers again. It was good to hear you and see you. So we will have now a lunch break, and we will be back at 2 o'clock exactly. Enforcement. So I'm really happy that we can start with György Kovács, who is an alumni of Ford University, professor here, and also a very active member of all types of social events at the university, member of our faculty.
Thank you very much, Polly, for this very kind introduction. Welcome, everyone. The first topic, my topic, the Digital Markets Act and its interplay with the General Data Protection Regulation. I understand that there was a lot of said about the DMA in the past 2 days. So I will only focus on the interplay and the practical consequences of the Digital Markets Act for data protection within the European Union. So the DMA is certainly a fascinating topic and a very important part of the EU's new digital economy legislative package, which we know, and which parts are going to become applicable in the coming years. Digital Markets Act, as we know, is a regulation of gatekeepers, so companies which can dictate the conditions for competition and market entry for smaller entities because of their dominant market power, which is usually a result of their profit-oriented use of personal data. If you just search for data or personal data within the DMA, for the search data, you can find 152 hits. If you search personal data, you can find 34 hits. So the GDPR is involved very much in the text of the DMA. You can see that the European legislators are aware of the risks of the DMA for data protection. That is why there are so many references to personal data and the full compliance with the GDPR. Regulating digital markets in the DMA, which are built on data-consuming business models, including personal data, creates an inevitable overlap between the GDPR and the DMA. Because these gatekeepers, they operate as multi-sided platforms, enabling 2 or more customer groups to engage with each other on their platforms by acting as a median, in which the goods and services are offered to the end users by the business users. The DMA covers core platform services from various sectors, from operating systems to online intermediation services, from cloud computing services to web browsers. Various sectors are covered by the DMA, and there are overlaps within, whether we are looking into the catalog of the duties under the DMA or outside of this catalog. There are many overlaps between the GDPR and the DMA. The question is whether the obligations under the DMA provide for a justification of the associated transmission of personal data under the GDPR. And this is the question what we have to look into in this presentation. Also, there is another question that will a different level of protection apply to gatekeepers with regard to the merging and commercial use of personal data? And does this differ from the previous assessment by the European Data Protection Board? In terms of looking into the text of the DMA, we can see that the DMA orders, it declares that its provisions, its obligations are without prejudice to the GDPR. And also in other provisions, the DMA wants to make sure that it complies with the provisions of the GDPR. There are, however, many questions which are left open by the provisions of the Digital Markets Act. Just to mention the most visible and most clear parts. For instance, in Article 5, the ban on the combination or cross-use of personal data sets. Or in Article 6, the portability and data sharing provisions. In all these areas, there is a need for additional interpretation, how the principles of data minimization should be, for instance, applied, how the requirement of the security of data processing is applicable for gatekeepers, how is it applicable for business users, how is it applicable when it comes to transferring, sharing data from gatekeepers to business users. So these are questions which where it is not enough to say that the DMA is without prejudice to the GDPR, but we have to look into the details, and there will be probably a need also for guidelines in the future. So to look closer to the text of the GDPR, there are certain provisions which clearly should be followed primarily, and which come into primary importance during the application of the DMA. These provisions are, for instance, that individuals must be informed about the use and the processing of their personal data during each steps of the data processing. So this means that individuals has to be informed by gatekeepers about all the steps of data processing. Also, when gatekeepers are sharing data with business users, and the same obligation applies to business users as well. And in terms of which data are shared, and this question of data sharing also invokes the purpose limitation principle and the data minimization principle under the GDPR. And then also there is a big question whether the legal basis for sharing data between gatekeepers and business users, the consent is enough. There is a lot of critique in the literature, what we can see that consent is not enough as a legal basis, and consent in itself does not provide enough safeguards for sharing data between gatekeepers and business users. There is a huge huge literature, and there's a lot of critics in this regard, and this is also probably an area where guidelines would be welcome in the future. And I already mentioned that that in the area of providing the level of security provided by the data processors, whether these are gatekeepers or business users, that is also a question which needs to be looked into more detailed. So we already touched upon some of these provisions of the Digital Markets Act related to the ban on data processing for advertising purposes, or to combine or cross-use data sets, which is only possible if there is a consent, or if other legal basis can be found under the GDPR, such as public interest or vital interest, and this is something what we can't find in the data sharing clause under Article 6 in the DMA. Here only consent has to be given that data could be shared between gatekeepers and business users, and this is given the inequality between the end user and the gatekeepers, given the information asymmetry, and also the fact that the end users are also, there is a kind of a consent fatigue, so to say. They are not reading the texts of the privacy declarations. So there is a fundamental concern whether the consent is enough legal basis for a vast amount of data sharing in the future under the DMA between gatekeepers and business users. So as I already highlighted before, the consent by the end user is one of the fundamental questions because of the inequality, information asymmetry, and the consent fatigue, which I already mentioned. And here there is a suggestion in the literature that DG Connect, which is going to be assigned to monitor the enforcement of the DMA, should particularly look into and establish a working group, a task force on monitoring consent requests under the Digital Markets Act. And the other aspect, which I have also mentioned, related to data security. Here, under Article 32 of the GDPR, it is clear that during data portability, data sharing, the security measures have to be taken both by the gatekeepers and also the business users. The question whether the gatekeepers should make sure that business users comply with their data security requirements can be a question for future guidelines. But based on the current guideline of the Article 29 work package, Article 29, we can say that the gatekeepers are not liable after they shared the data with the business users, and because of this, they also cannot block or restrict their obligation, or they cannot escape their obligation of data sharing under Article 6, Paragraph 10 and Paragraph 11 of the DMA because of citing security concerns. Because according to the current interpretation, they are not liable for such kind of data security concerns as the data was transferred to the business user. The business user has its own sphere of liability here. We also talked about the purpose limitation and the data minimization principle, which is particularly important when it comes to sharing data between the gatekeepers and the business users. Here, for instance, the exact timing of a transaction through which a computer model or which browser was used, it seems to be non-personal data, and in itself it doesn't raise any problems from personal data protection point of view. But when there is huge amount of such data is collected, there can be a risk for identifying or even profiling the end user, which raises the question of compliance with the GDPR's data minimization principle. And also there is another challenge to comply with the data minimization principle when the data point directly connected to the end user's use does not happen to have a meaningful business value for the business user. For example, the computer model used by the end user on which the transaction on the gatekeeper platform took place may not have any competitive advantage for the business user if the business user is selling a distinct product, such as cosmetics, for instance. However, the data point gets created with the direct use of the end user and therefore falls into the scope of Article 6.10. And under Article 6.10, such data point must be shared with the business user. And according to the critics of this provision, the wording of the article contradicts to the data minimization principle under the GDPR as well. And then also the requirement of transparency under the GDPR has to be followed during the application of the Digital Markets Act. Here, the European Data Protection Board has emphasized in their opinion that each receiver in the data processing chain must give people access to transparent information about their data processing activities. This would also apply in the context of the Digital Markets Act. Gatekeepers needs to inform the end users about all the processing activities, including data sharing with the business users. However, since the data points to be shared would differentiate based on the use of the end user, as well as the type of activity of the business user, it is likely that the information notice should also be given based on during the specific data sharing. So it is possible that gatekeepers may not know which data points would be shared with the business users, since they would not know which goods or services the end user would acquire in the first place. Therefore, the gatekeepers and the business users are equally obliged under the GDPR to share all information regarding data processing steps with the end users which they have available. Regarding the enforcement of the Digital Markets Act, do I have one more minute? Okay, thank you. So regarding the enforcement of the Digital Markets Act, there are two major questions. The first one is that how can different supervisory regimes be reconciled so that the concerned bodies can be mutually benefit from their supervisory authorities. Under the DMA, the European Commission is tasked with the enforcement, and under the GDPR, the national data protection authorities. And the other question from the perspective of enforcement is that can one and the same behavior which violates the Digital Markets Act and the GDPR also be punished cumulatively under the two sets of the regulation, each with substantial fines. And as closing thoughts here, it is important to point to Article 47 of the Digital Markets Act, which says that the Commission may adopt guidelines on any aspects of the DMA in order to facilitate its effective implementation and enforcement. And these questions of interpretation related to the DMA, which we have discussed, namely the application of the data minimization principle within the context of Article 6, or the limits of the gatekeepers' duties for informing the end users about possible data sharing in the future, or the question of defining the responsibility sharing between the gatekeepers and the business users in terms of security of data transfers. These are questions related to the interpretation and application of the GDPR in connection with the DMA, where such guidelines from the Commission would be clearly welcome in the future. And there is another important body which is mentioned in Article 40 of the DMA, and this is the high-level working group, which includes the European Data Protection Board and the European Data Protection Supervisor. And this body also has the role to establish sector-specific guidelines which can be established in a hybrid way, both incorporating data protection principles and securing the aims of the Digital Markets Act. So to conclude, the European Data Strategy, published by the European Commission, aims to make the European Union a leader in the data-driven society. However, such an ambitious project holds risks for privacy and data protection rules, as we can see. The Commission acknowledges these risks. The single market for the data will be built upon full compliance with the privacy and data protection rules. The DMA, despite its narrow focus on gatekeepers, will have a crucial place for the data protection standards in the European Union, since the gatekeepers are the most extensive data holders in the digital markets. Thank you for your attention.
Thank you so much. We have seen lots of obligations here, like competition law is based on prohibiting doing something. So here we see we must do plenty of things. So let's see how that relates to competition law, data protection, GDPR, and using data by from fellow PhD student Fatma Serend Morbe from the Károly Gáspár University. Welcome, and we are very curious.
you very much. Good afternoon. My name is Fatma Ceren Morbel, and I'm a first-year PhD student at Karolik Kashbar University. So today I would like to speak about the topic, namely EU competition law as a tool for data protection. So we know that we live in a digital era. At least we use one of the social media platforms such as Twitter, Facebook, Instagram, or LinkedIn, and they all collect our data. So the problems related to collected data and privacy issues are linked to the privacy paradox. Do we care our privacy in online? Yes, but do we read all the privacy policies in the internet? Not really. So the privacy paradox is a term that relates to the fact that while most consumers claim that they care about their privacy, actually, in practice, their actions do not confirm their claims. So, as a result of this paradox, problems arise that relate to both data protection law and competition law regarding privacy and market efficiency. Since consumers exchange their data as a currency, some kind of currency, to obtain goods and services, it enables companies to get big data sets, and they can use these big data sets to enhance their market position and also to create market barriers for new entrants. To explain how data can be a way to reach market power, I would like to draw your attention to two-sided markets. Two-sided markets can be defined as a meeting place for two sets of agents who interact through an intermediary. So, two-sided marketplace business model facilitates direct interaction between suppliers and customers, creating value through an intermediary. Facebook is an obvious example of two-sided markets. On Facebook, advertisers pay advertising fees for advertising slots, and when we look at the users, they do not pay anything, but actually by sharing their data, it's creating some kind of currency to obtain Facebook's services. So, for example, when you like a pair of shoes on Facebook, you will start to see shoe advertisements. So this is how it's working. As long as you are active on Facebook, Facebook will collect more data about you, but actually, this is where we have a problem with it. Because users are kind of locked in Facebook, since everyone is in Facebook, and it creates some kind of natural monopoly. Privacy breaches can be a concern under competition law as long as companies consider data as a source of market power. As a result, there have been a growing number of competition cases related to privacy issues. So, how the case law is shaped? It started in 2006 with the Asnaf-Equifax case, but in this case, the judgment of the court was that data protection law and competition law are two separate areas. Also, any breaches of data protection aspects should be investigated only by data protection authorities, rather than by competition authorities. So the approach was that privacy matters are not in the competition law area. 2 years later, we have Google DoubleClick merger case. Even though a significant number of participants voiced concerns about not only from the competition law aspects but also related to privacy issues, the Commission still holds the same approach with the Asnaf case. Privacy issues should be solved by only data protection authorities. Again, two separate areas. So it was the step 1. When we move on to the step 2, it gets more interesting because it is the first time when we see privacy as an important parameter of competition law. It can be seen as parallel in two cases. First one is the Facebook-WhatsApp merger case in 2014. E-Commission states that the merged entity can start collecting data from WhatsApp users with a view to improving the accuracy of the targets served on Facebook to the WhatsApp users that are also Facebook users. This is the moment when we had the data being recognized as something that can strengthen the market power. However, if we look at what happened in relation to privacy, it is still not much discussed to the aspect of the case. After all, if you look at Commission's conclusion, privacy is a crucial driver of the competition in the consumer communication sector. Later on in 2016, we have Microsoft LinkedIn case. Privacy could be viewed as a quality parameter in a competition law since it is being raised as an important issue. It was stated that privacy is an important parameter of competition law and driver of customer choice in the market for professional social networks services. The Commission realized that, for the first time, the element of quality can provide a way of incorporating privacy. Bundeskartellamt, the German competition authority's pioneer decision on Facebook, is where we see they talk that a breach of privacy can potentially infringe both competition law and data protection law. In 2016, the German Competition Authority initiated proceedings against Meta based on its imposed conditions on its users by requiring them to choose between disclosing their personal data or ceasing the use of service. According to the imposed conditions of Facebook, the users had to consent to the collection and use of personal data from other platform services of Facebook in order to be able to continue to the use of Facebook social media services. After 3 years, the Federal Cartel Office, Bundeskartellamt, prohibited Meta from making the use of its social networking in Germany conditional on the collection of the user data from WhatsApp and Instagram. The decision was the first decision by a competition authority explicitly addressing privacy protections. According to the Bundeskartellamt, since Facebook services were only available with the consent of the users, there was no effective consent, and it wasn't free. Based on the findings, as I said, this consent was not effective and free under the meaning of the GDPR. The users of Facebook didn't have any bargaining power to choose between privacy preferences and continue to use Facebook. Consequently, abuse occurred as a result of exploitation of the user. Therefore, the data protection boundaries of the GDPR were violated, and due to the Facebook's dominant position in the relevant market, it was necessary to analyze it from the competition law perspective. Following this decision, Facebook appealed to the Düsseldorf Higher Regional Court against the decision of the Bundeskartellamt. Due to serious concerns regarding the Bundeskartellamt's decision, the Düsseldorf Court ordered the suspension of the decision. As a result, the court ruled that Facebook didn't have to follow the Bundeskartellamt decision. The court emphasized that the imposition of Facebook's terms of service on its users didn't create a causal link between the dominant position in the market and the abusive behavior. However, the German Federal Supreme Court remitted the case to the Düsseldorf Court, which in turn referred it to the European Court of Justice. Recently, a few months ago, in September 2022, the Advocate General Rantosh expressed his opinion on the Meta case before the European Court of Justice and agreed with the approach the Bundeskartellamt. And if the opinion of the Advocate General Rantosh is maintained by the court, that can be meaning that competition authorities and data protection authorities can cooperate together. In the doctrine, we see that different approaches such as separatist and integrationist. Even though separatists hold the same approach with the ASNEF case, when we look at the objectives of the GDPR and EU competition law, we will see some shared objectives, such as protecting vulnerable consumers, consumer welfare, ensuring market integration, and counterweight to power and information asymmetries. I would like to analyze and conclude why EU competition law can be a tool for data protection. Firstly, it can be explained within the framework of Article 7 of the Treaty on European Union as an institutional coherence of the EU. A fundamental aspect of the Article 7 is to ensure that the common values of the EU, including the rule of law, are respected by all member states. Also, the EU institutions should ensure that and respect that the rights contained in the EU Charter of Fundamental Rights, including the right to privacy and data protection, and to promote their application. EU institutions should ensure that their policies are consistent as part of the effort to enhance the effectiveness of data protection law. EU competition law should be applied alongside data protection law, but in certain instances. Also, data protection law and competition law may be able to work more closely together by integrating and collaborating in order to address the difficulties that may arise due to the convergence of these two policies in the digital marketplace. Therefore, economic efficiency can be achieved in the internal market. So, competition law and data privacy are overlapping in the digital economy. But this doesn't mean that competition law should be extended to cover every data problem, but only cover if privacy-related harm relates to the market failure, so not to the privacy rights itself. Thank you for your attention.
Thank you very much. So, that's the protection here. Let's see how we can use data by Zsófia Maka from Vodafone, who is also an alumni of the university, and she was studying also in the US. So we are looking forward to the practical application of data in competition cases.
So, ladies and gentlemen, good afternoon. It's an honor to present here. My topic is the role of data and data protection in competition law assessments. First of all, welcome to the jungle. First, I would like to start with introduction to the interrelation between competition law and privacy. Then I would like to proceed by talking about the role of data in defining the relevant market, then the role of data in assessing market power, then talk about privacy considerations in merger reviews, and then privacy consideration in abuse of dominant position cases. So the OECD already stated in 2020 that the business models based on the collection and use of consumer data also raise new questions for competition policy. They have benefits such as providing innovative goods, services, and business models, but the business use of consumer data also raises concerns such as how to preserve privacy and ensure that businesses and other actors do not use consumer data in ways that disadvantage consumers. In that context, consumer data is broader than personal data, I have to say. It's data on consumers that is collected and traded as part of the commercial relationship between the data subject and the undertaking. When we talk about privacy and competition policy, they also have interrelation and relationship, but they have to be applied for distinct reasons. Privacy deals with the processing of personal data and the free movement of personal data, while competition policy prohibits aims for economic efficiency and consumer welfare, as you can see. But undertakings also collect an increasing range of data on consumers based on interactions themselves, which raises the quality of privacy as a growing source of concern in digital markets. And some studies argue for considering privacy as a quality dimension of competition and competition privacy, which also leads to the question, is there a competition privacy itself, the level of privacy and quality of privacy? Some studies also argue for using privacy as a normative yardstick for competition. While devices also unites us. Privacy and competition also share a number of interconnecting goals, such as building consumer trust in markets and advocating for data portability, which also leads to switching. But I would like to recommend looking at consumer choice. Privacy deals with consumer choice as granting the individual data subject the right to give his or her consent for the data processing activities, while competition law deals with consumer choice from the point of consumer welfare through the protection and promotion of the competitive process. So competition policy is not framed in terms of on the individual's rights or interests. It seeks to achieve the benefits of individual consumers collectively. And should we talk about effective consumer choice? Effective consumer choice is hampered by a number of different factors, commonly termed as demand-side distortions. Demand-side distortions are issues hampering the functioning of markets and the free effective choice of consumers. It can be divided into two categories, namely information asymmetries and consumer behavioral biases. Among the information asymmetries, we can talk about long and ubiquitous terms and conditions and complex products, so consumers may not be able to grasp the implication of allowing data collection, which leads to no disciplining effect on the behavior of undertakings. We can also talk about the use of dark patterns, which are manipulative user interface designs intended for consumers to take unintended actions. And we can also talk about consumer behavioral biases, such as the free effect or the privacy paradox that was also mentioned by Ms. Morbell, and inertia bias when consumers stick to the use of the service or product for the reasons of commodity, even though the quality of the service or product is declining. And I would also like to draw your attention to the GVH market analysis regarding the role of big data in e-commerce and the associated consumer awareness and data collecting practices. And the GVH found that Hungarian consumers know little about the data collection and data processing practices of online stores, and a considerable number of them are afraid that their data provided during online shopping will be misused. And then we arrive at the main challenges of competition law in digital markets, which are defining the relevant market, assessing market power, assessing the anti-competitive behavior of the given undertaking, and tracking mergers that are not notifiable under the UMR. First, we can talk about defining the relevant market. There is a traditional assessment which uses the SS-SNP test, but it only relates to changes in prices. But in digital markets, the user choice is driven by non-monetary factors, such as the number of users on a given platform. So some studies argue for the use of the SS-NDQ test, which is the small and significantly non-transitory declining quality, whereby a hypothetical monopolist can reduce a parameter of product quality without losing users. And then we can arrive at the question, what can be considered as part of quality? It can relate to privacy, user-friendliness, security, and other factors. But it has practical difficulties. We have to face it, such as the heterogeneity of consumer preferences, demand-side distortions, and the lack of an and the main reason is the lack of an objective and widely accepted definition of quality, which leads to the question how to select the relevant characteristics. That's why it's advisable to offer it only in exceptional circumstances. The role of data in defining market power. So far, more attention has been paid on whether the use of data sets can confer market power or provide a competitive advantage, rather than asking if the quality of privacy is declining. It might influence competition on privacy. The Austrian Competition and Consumer Commission also found that the breadth and depth of user data collected by the incumbent digital platforms provides them with a strong competitive advantage, creates barriers to rivals entering and expanding in the relevant markets, and allows the incumbent digital platforms to expand into neighboring markets. The OECD also suggests using market shares to be based on users, number of users, and the share of relevant interactions. To sum up, the role of data in itself is under scrutiny, but the quality of privacy is not. And we arrive to the privacy considerations in merger review. According to OECD, mergers between businesses that use consumer data could potentially harm competition in two ways, either by reducing the quality of data protection and privacy and offering the relevant market, or by raising barriers to entry or raising rivals' costs through the merging of consumer data. As the following cases were already touched upon by previous presenters, I would not like to delve into the details. But what's curious about the Facebook WhatsApp merger, that the Commission may have realized its mistake, that it did not substantially investigate the result of the combination of personal data from the two services. Because first, Facebook stated that there are significant technical barriers to the matching of Facebook and WhatsApp profiles, but what happened in 2016, they did it. Or they intended to do it. And in January 2022, Facebook had to explain to the CPC network whether users were properly informed about it. Then this request was reiterated in June 22, and then it led to commitments from the side of WhatsApp to explain what changes it intends to make and how they could affect their rights. They also have to, if they introduce new amendments to the terms and conditions, they have to include the possibility to reject updated terms of services prominently as the possibility to accept them, and there has to be a possibility for notifications to be dismissed or delayed. We can also talk about the Microsoft LinkedIn case again, but to me stood out in this case that Xing offered, that the Commission also considered that Xing offered stronger privacy considerations, so considered the offer of a competitor. And we can also talk about the commitments in the Google, Fitbit, and the customer Meta cases, which kind of signals more appreciation of privacy considerations reflected in the approved commitments, such as requiring the use of data silos. And we can talk about privacy considerations in abuse of dominant position cases, and we can talk about the interesting concept of essential facility, which can arise when a competitor unfairly restricts the competitor's access to data, preventing competitors from sharing data and withholding access to personal data from competitors. And there is a test for it, but all the 4 steps have to apply cumulatively, so there is a little or narrow chance for it to actually happen. The OECD also acknowledges the potential for an undertaking with market power to reduce quality with respect to privacy, and we can talk about the privacy as quality theory. In that sense, market power could also manifest itself by bringing forth decline in privacy, and through the application of this concept, privacy-enhancing services can be promoted, in theory at least. And we arrived at the infamous Facebook case, which was touched upon by many presenters again, so I would not like to bore the audience with presenting the facts again. But the Bundeskartellamt stated that the extent to which Facebook collects, merges, and uses data and user accounts constitutes an abusive dominant position. And it's really interesting that the data was already collected when several websites were called upon that contained the like or share buttons. Imagine it. And so due to the dominant position, the Bundeskartellamt claimed there is an existing imbalance between Facebook users and the social network, which provided for, indeed, no possibility for voluntary and free consent due to a take it or leave it situation. And it also said it appears to be indispensable to examine the conduct of dominant companies under competition law, also in terms of their data processing procedures. And at the bottom of the slide, we can see the legal opera happening again, which when we arrive at the opinion of Advocate General Rantos. I would like to touch upon the part of his opinion where he talks about the competence of national competition authorities. And he stated that GDPR does not preclude authorities, other than the supervisory authorities, to take account as an incidental question of the compatibility of conduct with the provisions of the GDPR. And the compliance with the GDPR may be a vital clue whether that conduct entails resorting to methods prevailing under merit-based competition, but mere non-compliance with the GDPR does not amount to abusive dominance. And about the cooperation between the several authorities, the Advocate General Rantos stated that the national competition authorities have the obligation to inform and consult with the supervisory authorities under the GDPR. What was really interesting and what stood out was also the prohibition on processing, on the interpretation on the processing of sensitive personal data and the conditions applicable to consenting to their use. Basically, Advocate General Rantos stated that the practices that could reveal situations attributed to these processing of sensitive data should be prohibited, and the exception raised by Facebook under Article 9(2)(e) of the GDPR, which is relates to personal data manifestly made public by the data subject, is not relevant here, because the data subject needs to be fully aware of the fact needs to be fully aware that he or she makes the personal data public by an explicit act. And usually what happens on the platform is only the administrators have knowledge what happens on the platform, and the use of cookies is not sufficient in that regard. And finally, we arrive at the validity of consent to the processing of personal data given to an undertaking in a dominant position. And Advocate General Rantos stated the mere fact that an undertaking enjoys the dominant position does not render invalid of the consent provided by the data subject. However, dominance does play a role in the assessment of the freedom of consent. As you can see, according to the following list, the controller has to demonstrate the existence of a clear imbalance of power between the data subject and the controller, that there is any requirement for consent to the processing of personal data other than those strictly necessary for the provision of the services in question. The need for consent of the data subject has to be specific for each purpose of processing, and there is a need to, the undertaking cannot prevent the withdrawal of consent from, so has to avoid the withdrawal of consent to be detrimental to the user. So I would like to conclude my presentation, and thank you for your kind attention.
So I think there are lots of interesting questions. Thank you. Anyone from the audience who would like to ask? I think the mic ran out of batteries, so if you can come just here practicing. That's for the online audience, so, and practicing for the next conference when you will present.
Ladies and gentlemen, thank you for the chance to have my question up here. So my question is about consent, because to be honest, I'm really concerned and curious both from as a possible data subject and from a legal point of view, because if I understand correctly, consent will be acquired by the business user. And as I see, there are two scenarios where I, as a business user, could obtain my consent. The first one being when I visit a website, and then a separate consent will pop up, and it tries to acquire my consent through its own website. And then it will transfer the data based on my consent. But I have a significant problem in this, because who knows what type of personal and metadata is being processed by Facebook. How the business user can inform me in the consent message on what it will transfer from Facebook. If I don't know, it should don't know it either. So that's my first problem. The second problem is I can imagine a scenario where I will drink my morning coffee and 675 messages will pop up on Facebook, then that they made a legitimate interest test to directly find me and acquire my consent to get my data, which I don't know again, from Facebook. Both are, I think at least, that it's not viable for me to have complete information, thus my consent will not be legal at the end of the day. What's your opinion on the matter? Thank you.
So, who would like to answer these questions?
Maybe I can.
Okay.
Actually, your question is directly related to privacy paradox. For example, there is a research in 2008, and this research says that, concludes that, even though one person, and we are talking about 2008, even though one person tries to read all the privacy policies he or she encountered on the website, it will take more than 200 hours. So it's impossible. And we look at the now, there are more websites, there are more applications, and I think it's impossible to be informed about the data sharing process. So I think it's impossible to know how it will be shared, whom they can reach to it. So that's my point.
Maybe I just would add that probably this is one of the reasons why in the literature there is a suggestion for the Commission to establish a task force at DG Connect exactly for checking the validity of this kind of consents in the context of the DMA.
As for my answer to your really technical questions, we also have some guidance right now after the Facebook case, and I'm really appreciative of the Facebook case because it set things into motion. We have some guidance on how to relate to the consent of dominant undertakings, but what about the non-dominant undertakings in the market? We do not know yet. So there has to be, for example, when I read through already when data flow starts, when the like or share button is called upon, it's just unimaginable. So, but right now, what is fortunate that the data is owned by really like dominant undertakings. So, in that sense, we are lucky. But on the other hand, in how to do that in practice, we only have theory yet and not practice, in my opinion.
Okay, any other questions? Yes?
I have a question on the objectives of the different legal branches that have been discussed by you. Because in competition law, the objective of fairness, how elusive it may be, seems to be endorsed to an increasing extent, especially by Commissioner Vestager. And this objective of fairness is also present in data protection law and in the DMA as well. To what extent do you see the fairness principle as something that could connect the different legal branches? And in relation to that, do you think that this principle means the same thing in these three legal branches?
Thank you. Anyone? Okay. Then I have an opinion on that. I'm a long-term proponent of the fact that fairness is not for competition law, because what is fair for one might be unfair for the other. So I think fairness should be left to courts. They are used to deal with fairness questions. So I don't like this push of fairness into competition law, but that's again happening, so probably we will see more cases relating to fairness. However, even though the ECJ refers to fair competition many times, it's not yet a central objective in competition law, as I understand it, for courts. So that's mainly a commission's proposition. And again, what I said in my presentation is that Commission cannot change primary law. So if based on 70 years of case law, fairness is not the primary objective of competition law, we will see whether it will stay that way or not.
So we need case law.
We need guidance from the ECJ, because that's the essence of competition law.
My quick thoughts may be that My quick thoughts may be that yes, fairness creates the imbalance of power between the players, but obviously in the DMA it's according to the market conditions. And in the case of privacy, it may be due to the access to information, again in relation to the privacy paradox and other factors. So I believe the core of the two things is the same, but it has some different meaning according to the different legal instruments and areas of law.
Thank you.
Any other questions? Yes. Data.
First of all, thank you for the wonderful presentations, and my question would reflect on the competition law side of data, and well, the question is for all of you, but it reflects in Zsófia's presentation mainly. Does the indispensable output criteria has to be lessened through case law? Does the ECJ, for instance, has to look at for instance, not indispensable, but convenient facilities in that sense to lower entry barriers? This is a brief question, but the answer doesn't have to be that brief. Thank you.
Again, it's only my opinion, but I do not think that we should use competition law for that thing. So it should be the data privacy, and we should not change concepts so easily. So we should opt for the use of privacy and use of data protection in that regard. But if it cannot be that with the instruments of data privacy, then we should talk about changing our policies in competition law. So that's my really short answer to your really complex question. And
if I reiterated it this way, in the point of view that how data could be a form of leverage for dominant players, should antitrust assess that question, or is it up to specific regulation or even privacy type regulation?
Again, a really complex question. I believe that obviously there is an overlap between the two areas of law, and we can develop some tests on how to assess these, but so my heart lies with competition law in that sense. We should keep competition law as close to the current practices as we can, in my opinion.
All right. Thank you.
I agree. Thank you. So no more questions. Well, I pose one question for the break, so we can discuss it during the coffee break. Like if the ECJ will go with Advocate General Rentos, then that will be very interesting to see how competition authorities, national competition authorities, can increase their competencies. Like, can they get some competences, more competences regarding the DMA, like using the same arguments? It's just an ancillary question. Yeah, it's in the DMA, it's for the Commission to decide, but it's like GDPR, so I can think about it and adopt a decision based on that. Or no, we will see. Thank you. Have a coffee break, and then we will be back in a few minutes. In 25 minutes, I see, okay? At 3:30. Thank you for the...
So welcome back to our last panel, dear guests, dear colleagues. Now we are going to finish the conference with a panel on the Indonesian perspective, and I'm really looking forward to this panel to hear from our colleagues from Indonesia and their perspective on competition law and consumer protection in the digital era. I would now like to call upon our first speaker in our panel, who is Fitra Devi Navisa from the Faculty of Law, Universitas Islam Malana. I would like to give the floor to Fitra Devi Navisa.
Okay, thanks for the time given to me. Introduce, my name is Nafisa from Law Department, University of Islam Malang. I am very proud to be a part of this conference. I will share about consumer protection in digital-based banking products. The development of information technology also shows change in people's behavior patterns in using bank services in line with the changing times. This incident prompts banks to offer innovation in bank financial services based on information technology or financial technology. Digitalization is not an option for banking, rather it's a requirement and an obligation. Clear assumption about speed, accommodation, adaptability, convenience, and accessibility of SAFER multiplied 24 hours bank administration requires SAFER banks in Indonesia to change to digital-based administration. The banking transition to a new era, particularly the digital banking era, was indirectly facilitated by improvement in information technology in customer service. This digital service for customer can be started from the beginning of the relationship between the customer and the bank, from opening an account to closing a saving account through the use of information technology. However, some problems have arisen to computerized financial administration, such as criminal violation, which are currently becoming rampant, and increasing data abuse procedures by untrusted groups. In today's digital era, cybercrime has arisen to the top of the banking world list of crimes. OJK regulation number 12 year 2018 concerning the implementation of digital banking services by commercial bank state that digital banking services are electronic financial administration made by increasing the use of customer information to serve customer more quickly and effectively, and as indicated by the requirements or customers experience, and can be done completely independently by the customer while taking into account the security angle. By financial advisory, investment, electronic trading system, or e-commerce transaction in and other needs of bank customer can all be obtained through this method, as well as information, communication, registration, account opening and closing, as well as information and transaction other than banking products. The financial activities of each customer are always influenced by digital banking, which develops along with technology advances. It's anticipated that digital banking services will offer greater convenience than current services. Customer will benefit from this convenience, but on the other hand, the service will also increase the risks faced by banks, especially those related to operational risks and reputation risks if there are problems related to digital banking. Watershed method, this research is a type of normative juridical research which focuses on examining positive legal norms and rules related to the problem under study. Then studies in normative law cover legal principles, legal organization, and synchronization in law. This study used two conceptual approach, namely the statutory approach and the conceptual approach. It's not common for friction to occur between banks and customer in this intensive interaction. And if friction isn't resolved immediately, it can result in dispute between the bank and the customer. Based on previous experiences, the four main factors that cause the emergence of such friction are, for the first, lack of information regarding bank product and services features. The second, there is still a lack of understanding of customers regarding banking activities and products or services. The third, inequality in the relationship between the bank and its customers, especially those who borrow money. For the fourth, there are not enough channels to help customers and banks resolve their initial dispute. Consumers are protected in POJK number 1 of 2013 concerning consumer protection in the financial services sector in terms of using bank digital products. This protection is largely based on the unbalanced position of consumers and financial service actors in practice. Consumers are in a stronger position compared to business actors who offer, sell, and promote their products. In this era of globalization, the services provided by conventional banks and Islamic banks are not only carried out in the traditional face-to-face mode and the use of paper documents, but conventional banks and Islamic banks have also begun to switch. The use of technology with a non-face-to-face model and the use of digital document called digital banking allow the Republic of Indonesia number 11 of 2008 concerning information and electronic transaction is the legal basis for electronic transaction. Legal action carried out using computer networks and or other electronic media are called electronic transaction. The use of electronic media and the existence of legal acts are two important aspects of electronic transaction which can be concluded from this understanding. Therefore, it's easy to draw the conclusion that in digital banking electronic transaction, the customer is one of the subject who also perform legal action. However, the use of electronic media so that everything in digital banking electronic transaction has moved from paper and pen to electronic document. This data is good news for world civilization because Indonesia is one of the countries that encourage banking institutions to keep pace with digital technology, which is the world need. In addition to the existence of digital banks that are growing quickly in Indonesia, several countries in other parts of the world are also participating in banking digitalization. The following is a table that provides data on the percentage of digital banking user with survey indicators for 20 and 21, the prediction for 20 and 26. Based on the table, it can be understood that the development of digital banking has become a world need and has become a future transaction ecosystem. The creation of a digital ecosystem certainly raises several issues and challenges as a result of the advance and availability of the technology mentioned above. Several obstacles have emerged in the realm of digital banking itself, both in terms of digital banking services and digital banks, which require banks to resolve them through a legal process. The first digital banking challenge is to measure the degree to which the digital banking framework can be implemented while maintaining two important perspectives simultaneously, namely business methods and continuing to provide security guarantees to customers so as not to harm customers to digital banking execution. In this case, legislation that focuses more on protecting digital banking consumer must strengthen than Financial Services Authority Regulation, or POJK, or Financial Services Authority Regulation. As of now, there are no further guidelines in this regard. The guidelines provided by Indonesia in the field of digital banking are very limited. The existence of digital banking and digital banking services is regulated in two OJK regulation, namely POJK number 12, year 2018, which regulates digital banking services provided by banks before the emergence of digital banks with full digital services, and POJK number 12, year 20 and 21. The second digital banking challenge is to provide a prudential and sustainable digital banking system. All banks in carrying out their business must continue to follow prudential standards, or also called fairness rules. This is stipulated in Article 2 of the Indonesian banking law, which explain that with the precautionary principle, Indonesian bank make effort based on economic democracy. Indonesian banking carries out its operation based on economic democracy and the principle of prudence. The precautionary principle means that a bank must apply it carefully in managing and carrying out their business activities to maintain bank stability. This is necessary because banks are a reputable public institution that work to maintain a country's monetary stability through sound financial transaction. The digital bank system, as regulated in Article 24, letter B, POJK number 12, year 20 and 21, directs that what must be owned by a bank conducting business as a digital bank is the capacity to handle computer's business that applies fairness and practical rules. However, even though it has been stipulated, the POJK profession are still incomplete, so it's necessary to set more detailed parameters, criteria, and step in the context of implementing the precautionary principle in the digital banking system. For the third digital banking challenge is risk management. According to the legal definition, risk management is defined in Article 1.3 POJK number 18, year 2016, on the application of risk management in commercial banks, which state that the preparation of methodologies and procedures for identifying, measuring, mapping, and controlling risks arising from all bank business activities is known as risk management. The set of methods and procedures used to identify, measure, monitor, and control risks arising from all business activities of a bank is known as risk management. The third digital banking challenge is risk management. According to the legal definition, risk management is defined in Article 1.3 POJK number 18, year 2016, on the application of risk management in commercial banks, which states that the preparation of methodologies and procedures for identifying, measuring, mapping, and controlling risks arising from all bank business activities is known as risk management. For the fourth digital banking challenge is having information technology-based governance and capabilities for digital bank directors. For digital banks to carry out their operation, they must meet one of the following governance and IT competency requirement for director. Article 24, letter T, POJK number 12, year 2021, explained that the Indonesian institution which oversees the financial sector and is tasked with conducting a fit and proper test for directors for the banking industry. However, a regulation regarding this matter haven't issue a specific regulation regarding the application and passing standard of ability, suitability for a candidate for the main Director of a digital bank. The fifth digital banking challenge is ensuring consumer protection against the security of personal data and the risks of data leakage. Trust is the basis and main foundation of the banking industry. To maintain it in addition to sound banking and banking intermediation function, another important aspect is the legal protection of customer data. Customer personal data is important because online users will not carry out digital transaction if they feel the security of their data is being threatened. One of protection of personal data relates to how customer data will be discussed, including personal data from customer or exchange with irresponsible parties, which will cause financial losses for bank customer. Article 24, letter E, POJK number 12, 2021 said that the implementation of digital banks is necessary to protect the security of customer data. Indonesia has not issued regulation or laws relating to the protection of personal data, so it can be said that this vacuum has occurred. However, it's known that Indonesia is trying to process the drafting of the Personal Data Protection Act or Indonesia Personal Data Protection Bill. This lack of regulation creates threats to privacy and management of personal data, such as data leaks. This, of course, will lead to something fatal and destructive if the regulation doesn't exist. Okay, in the following, the author provide data on cases of user data leakage in various business institution or platform in the digital world. The data above is just a fraction of all cases of data leakage that have occurred in several institutions in Indonesia. This problem should be known by the government and other parties. In addition, personal data protection regulation must be enforced in Indonesia immediately. Referred from the Jakarta Post, Pratama Persada, top of the Center for Correspondence and Exploration of Data Security, or CISSR-EC, or Center for Exploration of Data Security and the Correspondence Framework of Indonesia, said that computerized bank must increase caution and implement a satisfactory assistance framework to protect clients from errors that occur in the online world. He concluded the Indonesian Personal Data Protection Bill must still be passed because it will enable consumers to hold financial institutions accountable as the organizer of the digital transaction system. Okay. All Indonesian banks, including commercial and central banks, are subject to the entire system since Bank Indonesia is Indonesia's central bank. It's responsible for maintaining the country financial stability. In addition, the stability of Indonesia banking sector in financial system as a whole is another objective of Bank Indonesia. Specifically, in accordance with Law number 3 of 2004, Bank Indonesia has been assigned as monetary organization entrusted with accomplishing and keeping up with Rupiah state lines. Okay, so conclusion, digital banking and its services have developed and will continue to play an important role in development of the digital ecosystem in the future. This matter must be seen from the critical increase in digital banking in Indonesia. However, this scenario will present several difficulties, especially in the legal arena. Digital banking in Indonesia has guidelines, but is only limited to things, namely the benefits of digital banking and guidelines regarding the legal status of banks in Indonesia. Digital banking services are regulated in POJK number 12 and 2018, whereas POJK number 12 2021 regulates the legal status of digital banks in Indonesia. There are at least 6 challenges to implementing digital banking that must be met, namely innovative and safe business, prudent and sustainable digital banking, good risk management, administrative needs and IT skills for advanced bank management, customer guarantees for personal data information, and the risk of information risks. Okay, thank you for your attention.
Thank you very much, Fitriya Devi Navisa. And now we move on to the next speaker, but Fitria, please stay here for the Q&A at the end of the panel. So now we're moving on to the presentation held by Nanda Indravati and Endro Susilo from the Faculty of Law, Universitas Atmajaya, Yogyakarta. And the title of the presentation will be Assessing Risk Associated with Competition in Digital Financial Product and Service, a Case of Indonesian Financial Service Authority.
Okay, thank you for the opportunity. I will present about my paper with the title Assessing Risk of the Competition in Digital Financial Product and Services, a Case of Indonesian Financial Service Authority, or we call OJK. Indonesia, as a member of ASEAN, has signed a number of free trade agreements, like agreement between Indonesia and Japan Free Trade Agreement, and Indonesia between Indonesia and Korea Comprehensive Economic Agreement, or ASEAN and China Free Trade Agreement area. This trade agreement provides Indonesian consumers and businesses with improved market access for goods and services, new technology, and investment opportunities. On August 20 and 22, Indonesia ratified the Regional Comprehensive Economic Partnership, or RCEP, concluded by 10 ASEAN countries and 5 non-ASEAN countries like China, New Zealand, Australia, Japan, and South Korea. RCEP is more than just a free trade agreement that is limited to trade in goods and services. Rather, its 20 chapters are also cover about investment, intellectual property, e-commerce, competitions, government procedures, and dispute settlement. And the startup business sector related to e-commerce has been the most successful in attracting large investors in the ASEAN region is the financial technology. And this is the fintech in Indonesia. As of January 2020 and 23, a total of 102 fintech lending companies in Indonesia have officially been registered with Indonesian Financial Services Authority. OJK recorded that the value of fintech lending or online loans in January 20 and 23 reached 18 and 23 trillion rupiah, and the online loans were distributed to 15.93 billion borrowers. And this is the rule on the RCEP about the competition and consumer protection and about the e-commerce. RCEP provides for exchange of information among member states, competitions authorities, and allow for coordination and enforcement actions taken by them. This chapter also provides for technical cooperation to increase capacity in competition law enforcement. Cooperation is also provided for matters of mutual interest related to customer protections. In e-commerce, the RCEP stipulates that parties will adopt or maintain a legal framework conducive to e-commerce, including in adoption of law to protect data privacy and e-commerce consumers. The parties also agree not to impose custom duties for electronic transmissions. So, what is the problem and the challenge for Indonesia? RCEP has opened an access for foreign investors, especially on fintech industries. The fintech business is becoming the transboundary business. So, what about the authority of the OJK to deal with these conditions? How does the regulation anticipate? It is the two big questions for discussed in this paper. And what is OJK? OJK was formed based on Act number 21 of 20 and 12 concerning the Financial Service Authority. OJK was formed with aim that all activities in the financial services sector become organized regularly, fairly, transparently, and equitably, able to realize an economic system that grows sustainability and stably, and able to protect the interests of the consumer and society. The OJK has task of regulating and supervising financial service activities in the banking sector and the capital market sector and the non-banking financial industry sectors. In Article 47 of the Act Number 21 of 2011, OJK can cooperate with supervisory authorities for financial service institutions in other countries as well as international organizations and other international institutions, including in the following fields and/or activities: A. Institutional capacity development, including training in human resources in the field of regulation and supervision of financial services institutions. B. Information exchange, and C. Cooperation in the context of examination and investigation and crime prevention in the financial sectors. And this is the OJK regulations to supervise fintech developments. OJK has 3 regulations. First, regulation of OJK number 77 on information technology-based lending services. The regulation focuses on peer-to-peer or P2P lending businesses, and OJK supervision will be based on the prudential approach. Second, PIJK number 13 that cover innovation in digital technology for the financial sector. This regulation will serve as a legal umbrella for all fintech companies that have not been regulated by other authorities. And the third regulation is PJOK number 37 on funding services to IT-based stock offering. The regulation is to provide space for startup companies to obtain funding through the stock market as well as to enhance financial inclusions. And the regulation of Article 1.6 OJK regulations number 77 stipulated that fintech provider is Indonesian legal entities that provides, manage, and operated technology-based borrowing and lending services. So, based on the OJK regulation, fintech shall be Indonesian entities. Of course, the provision may be used as a legal basis to control fintechs owned by foreign investors. However, the provision has not been followed by the implementing regulation, so it is the problems. As the result, fintech industry are not fully and effectively controlled by OJK. And for the conclusions, the regulation governing fintechs, both owned by national and foreign investors, has not been able to control fintech business since they are not followed by the implementing regulations. In order to conduct fintech business and a consequence of ratified SCEP, the government should immediately enact the implementing regulation, especially in those providing legal basis to establish a body to supervise fintechs owned by foreign investor. If the government doesn't meet the implementation regulations about the problem, it is potential to make the competition between financial services sector become unfair. Thank you for your attention.
Thank you, Nanda, for this presentation, and we move on to the presentation to be held by Puspanginchas Panglia Purjati and Josephine Sarimurthy of the University Atmajaya Yogyakarta with the title Disclosure in Digital Advertising, an Overview in Indonesia Practices and Regulation.
Okay, good afternoon, ladies and gentlemen. Thank you for the opportunity. So me and Mrs. Sari can deliver this presentation titled Disclosure in Digital Advertising, an Overview in Indonesia Practices and Regulations. We Are Social, a digital agency based in United States, shared some research results of social media behavior in various countries, including Indonesia. The data shows that in 2022, firstly, social media users in Indonesia are 68.9% of the total population, up 12.6% from 2021. Secondly, related to reasons for using social media, 50% of the respondents using social media for finding activities to do or things to buy. Users also use social media to search for brands in online buying and selling transactions. The behavior of social media users shopping through social media platforms raises digital marketing trends. This kind of situation makes brands involve influencers, mainly social media influencer or SMI, as intermediaries who connect brands with consumer or social media users. As we know, SMI are people who, because of their position and constant presence in social media that allows them to have an impact on the receivers, are engaged by companies for advertising purposes. Related to business model in digital advertising, there are some models that usually used between brands and SMI. First is affiliate marketing. Through social media, influencers direct consumers to a link to the brand's website to transact there. Influencers are compensated based on the transaction consumer make based on the link shared. And the second is exchange of goods and or services. Influencers promote goods or services that are given to them for free. For example, clothes, makeup, games, travel package, dinner, hotel accommodation, or etc. And the third is endorsement deals. Influencers create advertising content on their social media, and influencers get compensation for the content that they create. And the last is merge category. In this category, influencers create products with new brands or create products using existing brands, collaboration with the existing brand. By using SMI as an advertiser, there is a potential for confusion about the function of social media. Consumers may be confused about the content provided by trust peers or SMI, misleading content. The involvement of influencers in digital marketing raises various legal problems, including the challenges of consumer protection and unfair business competition. Advertising Standard Authority in United Kingdom informed that from 24 to 208 Instagram stories that are assessed, 76.3% are editorial content and the rest are ads content. But from 64.9% content of the ads content are insufficiently labeled as ads. This problem brings an obligation to disclose any information, especially material connection between the brands and the influencer, related to the origin of content by the SMI. So, the question is, when to disclose? First, when brands have editorial control over influencer content. The second, there are proportional messages in influencer promotional messages in influencer content. Third, there is a compensation or material connection between the influencer and the brand. And there are some do's and don'ts in disclosure obligation. Do's: genuine and based on the real experience of influencer. And then the second, clear and conspicuous disclosure. No blanket disclosure. A one-time disclosure made by an influencer, for example, only on the bio Instagram profile. Prominent position. at the beginning of the content, not at the end of the content and easy for consumers to read. And the last is disclosure is delivered in language appropriate to the language of the content. And the don'ts, the social media influencer shouldn't act as if he is a pure consumer, as if he bought a product when in fact he was given or lent by the brand to promote the product. It is as if he is using the product or service being promoted when he is not, taking a brand from a brand without providing further disclosure and etc. The problem, failure to include disclosure by following the criteria can be categorized as misleading omission. What is misleading omission? A legal term referring to dishonesty or the absence of information that could mislead or deceive someone in making a decision, and includes unfair commercial practices. Such advertising practices can be referred as covert advertising, a marketing strategy in which advertisements are inserted into content without informing the audience that they are advertisements. And then the last is deceptive commercial practices or misleading and dishonest marketing practices. Consumer autonomy in making decisions is not only crucial for the relationship between business actors and consumer, but also supports market transparency. Now we'll see some perspective in various countries. First, the Swiss Federal Act Against Unfair Competition. In that regulation, anyone who acts in a misleading manner or non-transparent marketing practices have already been qualified as unlawful in the market or in another way against good faith principles. The United States Federal Trade Commission also has in the endorsement guides and disclosure 101 that regulate the same thing. And then United Kingdom, with the Competition and Market Authority, published the guidelines for the influencer regarding the obligation to disclose material or commercial relationship between the brands and influencer. In German Unfair Competition Act, advertisement which has not been properly marked is treated as anti-competitive practices. In Canada Competition Act prohibits deceptive marketing practice. The market works best for everyone where consumers can make informed choices. So how about in Indonesian regulations? In the law number 5 of 1999 concerning prohibition of monopolistic practices and unfair business competition, in general, this law prohibits forms of marketing that do not support fair business competition. Law number 8 of 1999 concerning consumer protection. This regulation regulates how business actors advertise goods or services, but doesn't further regulate advertising by social media influencer as a representative of business actors, because in this law, SMI cannot be categorized as a business actor. Government Regulation number 80 of 2019 concerning trading through electronic system. In the case of electronic advertisement delivered through media, intermediary services in mandatory comply with statutory provisions in broadcasting, protection of privacy, consumer protection, and do not conflict with the principle of fair business competition. And then regulation of the Minister of Trade number 50 of 2020 concerning provision of business licensing, advertising, guidance, and supervision of business actors in trading through electronic system, same as law number 8 of 1999, showing result reviews and testimonials from past customers must use good and their service include have ensure the truth information on the identity of the legal subject concerned and done responsibly. And the last is Indonesian Advertising Ethics 2020 Amendment only regulates about endorser, whom characters or ordinary people displayed in advertising message to invite other people use or consume a product advertised, without suggesting that he was himself have used or consumed related product. But there is no further article that regulates about how they should advertise the product or services. And the conclusion and recommendation. The regulation in Indonesia do not regulate contracts between brands, especially obligation to disclose the material connection between the brand and the social media influencer in the content. Regulation in Indonesia do not regulate contracts and the other essential aspects of contract law, consumer protection, healthy business competition, and etc. Considering the development of the use of social media in digital advertising carried out by brands and influencers in Indonesia, and looking at development in a number of countries, more detailed and comprehensive arrangement regarding digital advertising by influencers are needed. Bu Sari, do you want to give any additional? Enough. Okay. Thank you once again. Good afternoon.
Thank you very much for this presentation, and I would now like to open the floor for questions or comments. Yes, please.
Just one short question. Is there any regulation or thinking of regulating these dark patterns, like influencing the subconscious with UX design or stuff like that? So do you have any regulation on that, or practice, or thinking about such a regulation?
Okay, thank you, Paul, for the question. As I said in the presentation, that in Indonesia there is no regulation that already concerned about the third parties that advertise the product or the goods or services. And in this presentation, I recommend the government to think about that, because the development of digital advertising in Indonesia is so goes so fast that I think it's important, because in my experience, there are just a little influencer that already disclose this, the material connection between them and the brands. Thank you.
I have a question to Nanda Indravati. So you talked about the fact that implementing regulations are missing for controlling fintech businesses. Can you tell us why these are missing? Is this an omission on the part of the OJK?
Okay, as I has told before, that OJK just have regulations for supervising for the non-commercial or we call as fintechs, but OJK doesn't have the implementing regulations. How about the OJK makes their authority, because the business of the fintechs in this area is transboundary, because OJK have, Indonesia have ratifying this, the RCEP, but the regulated in Indonesia doesn't enough to regulated how to supervising the foreign investments, especially in fintechs.
So it may be a jurisdictional issue. In a way, like, do they have competence? The question is if they have competence to supervise a foreign-based business.
Okay, maybe Pak Indro will answer the questions.
Yes, thank you. It's very common. Usually a regulation or statute doesn't apply just because we lack of implementing regulations. And back to this fintech, yes, there is regulations that even though the fintech is owned by foreign investor, it should be based on legal, it should be established based upon Indonesian regulation. The law on what we call, law number 40 of 2070. So it shall be based on Indonesian law. Then OJK has the authority to supervise those, But again, as Nanda said, we lack of implementing regulation, and that actually is not just concern about OJK. In some cases, in some areas, a statute sometimes couldn't be implemented just because it lack of implementing regulation. Only 3 years later, 5 years later, when the implementing regulation was enacted, then there will be a comprehensive regulation, and then at that time, the law could be enforced in controlling things, or in supervising, like fintech. That's my additional comment. Thank you.
Thank you very much. Any further questions? Yes, András?
I'd like to have just a short question regarding the last presentation. It's highly interesting to see that there is some regulation, some ethical-based regulation on advertising, for advertisement in India. And I'm just curious whether this is a legally binding legal measure, and if yes, in what way this ethical rule can be enforced, or who is responsible for enforcing that. Thank you.
Thank you, András, for the question. So sorry that I have to say that Indonesian Advertising Ethics 2020 is not legally binding, and because it's only regulated by the organization of journalists, maybe, and it's not legally binding that the nature of the regulation is only a soft law. Yeah, Bu Sari, maybe you want to give additional about Indonesian advertising ethics, is legally binding or not?
Yeah, okay. I will give a comment about the question from András. As I know that the organization of the advertisement has a ethical, but as we know that ethic is beyond the law. So it is depend on the consideration or the yeah, I think the ethic is not like the law, binding as a law, but this is beyond on the law. This is my comment addition. Thank you.
Thank you. Any further questions? I just have one comment on the first presentation by Fitriya. I found it exciting to see that you made a comparison on the future development of digital banking. And I was looking at the data on Hungary, and it was one of the lowest for 2021, but also the projection of use of digital banking services was one of the lowest. So you estimated a growth to 29% from 18%. And I was amazed that the growth in this sector is going to be so low, with a penetration of 50% in Brazil. So that was exciting for me to see, especially now that we have digital banking across member states as well. If there are, oh, Henry, yes, please come forward to ask your question.
She told me that electricity was down. So sorry, this is still Indonesian phenomenon. But since I read also Fitriya paper, so we have actually two questions in this context. One is the ubiquitousity of digital product, which goes beyond the coverage of our central bank. So we have two authority. One is central bank, the other is OJK. But central bank is so important in managing macroprudential, but also the preventions of disruption in payment. The second is the question is on the context of how our legal system could also cover the transboundary, since Nanda also present this, transboundary services which come to Indonesia. As McKinsey took note, I think 5 years ago, we'll have another 50 millions which can reach internet in the next perhaps 7 years, and most possibly they will also enjoy digital banking product, which also still that our central bank need to catch up. So this is what Fitria said. Thank you.
Thank you for your comment. Yes, Henki, please come forward to ask the question.
Okay, thank you very much. I think Indonesia Advertising Ethics 2020 amendment, in Indonesian perspective, you know that how about policy rules. I know because Indonesian Advertising Ethics 2020 amendment are different from laws or regulation because they only bind internally to the state administrative officials. So are different from laws and then or regulation, because you know that and have indirect binding power. So and then illegally binding Indonesian Advertising Ethics 2020 amendment. So you know that policy rules. Yeah, it's same that's policy rule. Okay, thank you very much. Okay.
Thank you. Any further questions or comments? If not, then I would like to close this panel and thank the presenters for their wonderful papers. Thank you also, Fitria Devi, for your presentation online. And I would now like to give the floor to András, who will be speaking some closing remarks.
Yes, so as to conclude to this 2 days conference, I'd like to say thank you for all the participants and also for the support for the Atma Jaya Jakarta University and especially Henry Thomas in giving support to organize this wonderful event. And I think that we can conclude that those challenging issues regarding the digital transformation and in relation with competition law were discussed into the detail, and I really hope that this was a beginning of a future discussion among the participants. So thank you very much for your effort, your participation, and looking forward to further cooperation. Thank you very much.